accommodation in respect of item numbers 23 and 24. Actually, there is a big arbitration matter which is continuously going on since day before yesterday. 23 and 24.
23 and 24.
My learned friend appears on the other side. We have arrived on a consensus date.
22nd of July.
If it can be fixed on 22nd of
22nd of July.
22nd of
Yes.
July.
July. Mr. Broadcaster is ready.
Hello.
Agreed.
Because the Advocate General made a request, and also I can't, my lord.
He has always been very kind.
Mr. V. Broadcaster, the learned counsel for the appellant, and with the consent of the other side, the learned Advocate General, and paid for an adjournment. Why we need, what is the reason actually?
Actually, there is a part heard matter going on before the learned district judge. It's a big arbitration matter pertaining to the state. So that is continuously going on since day before yesterday. So today also it will go on the whole day.
So to do some personal conflicts. Accordingly, the matters accordingly on 22nd of July.
22nd.
22nd.
May I please, your lordship, my lord? Item number 6 and 7, my lord, they filed affidavit in opposition. So I need some time to file reply. 6 and 7,
6 and 7.
my lord. And my lord, lordship may kindly fix the matter on 22nd. By that time, my lord will file.
So all the respondents have filed their affidavit in
Yes,
application, or
No, education department.
Education. We have filed, man.
you are the for the respondent number?
Yes, for education department. This is all
Education
education department. Standing council education.
Standing Council Education Department. In item number 7 also.
7 also,
the
my lord.
Education Department is in
Education
Yes,
department.
yes, 6 and 7, madam.
6 and 7 portion.
Of course, subject matter is different.
On the subject matter is different, otherwise.
Otherwise,
Achha.
madam. Same, madam. Same.
Same for admission matter available ke order kori. Item number 6 today, had Mr. A. Protest to the learned counsel for the petition, and also had Mr. KSN. G. Takun, the learned standing counsel for the education. Oh, no, Mr. Purcast is for the respondent,
Petitioner,
Oh,
madam,
I'm petition.
for
for
petition.
the petitioner, but
Yes.
here it is in a cause list.
All this.
So see the cause list.
Madam, but the first 6, his name is not replied. Oh, it's wrongly is typing because wrong.
Lordship is right.
Yes, otherwise I know you for the
Yes, yes,
petitioner.
yeah.
So and so. Submitted by Mr. Broadcaster that he needs some more time to file affidavit in reply against the affidavit in opposition filed by the respondent. Prayer alert. Twitter tag ke hoga. List according, do you have any date of choice here?
My lord, 22nd of July.
22nd
Same.
of June.
By that time, we will file.
And my lord,
Yes.
I beg to mention item number 18, my lord. It's
22nd.
also, my lord, from petitioner, my lord, learned seniors appearing, my lord. 18, my lord. I'm here for the education department, my lord. Here we have not yet received the parawage comment, my lord. So
Till
the,
now, you have not filed your affidavit. in
my lord,
opposition.
my lord.
I'm petitioner.
Oh.
And my lord, lordship kindly, then by that time, my lord, they will file, fix the matter on 22nd.
My lord.
22nd. With the consent of the petitioner side, Mr. T. Takun, the learned standing counsel for the education department, paid some more time to file their affidavit in opposition. Parawise committee already.
Not yet received, my lord.
Submitted that the Parawise comment is not yet received from the concerned department. Mr. Pukast, the learned counsel for the petitioner, did not raise objection. List the matter accordingly on 22nd of July. However, the education department is hereby directed to file their affidavit in opposition on or before 22nd of June.
My lord.
My lord, as also, my lord, one matter. my lord.
Item number 1. My lord, item number 1, my lord, they raised a question the other day, whether it is maintainable.
Yes, it's a.
Because we have challenged the charge sheet. pertaining to a departmental proceeding. And I have checked up, I got my number of decisions on this point, my lord, there is no absolute bar. Whether writ petition is maintainable or not maintainable. I say that my lord, writ petition is maintainable. So Lordship may let the matter come up
My lord,
and Lordship may issue notice and it may,
My lord.
and they may.
That's all right. My lord, I beg to mention at number 16, my lord.
No, just.
My lord, that part, my lord,
Item number 1
My
is
lord,
an
this-
issue of maintainability.
My lord.
So now you are going to argue this matter and.
My lord, argue the
maintainability?
matter in the sense, my lord, if Lordship is otherwise satisfied after looking into the relevant decision, Lordship may issue notice and by that
My
time
lord.
they will. file their
No.
affidavit.
May I
if the
suggest,
ma-
my lord?
If the maintainability issue has already been raised, suppose.
Yes.
So in that case, we have to hear the matter. If it is not at all maintainable, in that case, it's not.
Then Lordship
not-
may kindly fix the matter on 22nd.
22nd,
the
but that's why, my
second.
lord.
At least, my lord, they were directed to obtain certain instruction.
My lord,
Yes.
that's why, my lord.
We raised the question of malafide.
In the meantime, I'll obtain instructions of the case as well as I'll raise, since we have raised the maintainability, we'll argue on that day, my lord. 22 as
Yes.
convenient.
Heard Mr. A.K. Procastor, the learning counsel for the petition, and also heard Mr. T. Tagan, the standing counsel, education department. It is seen that on the last occasion, the maintainability issue was raised before this court and accordingly, the respondent was also directed to seek instruction from the authority concerned. But it is submitted by Mr. Tagun that inadvertently they could not obtain the instructions from the concerned department. Full stop. In view of that, the matter be listed on 22nd. It is on
March.
22nd of July, 22nd of July, enabling the respondent side to get instruction from the authority concerned. And the matter may be heard on the point of maintainability.
Deeply obliged.
Obliged.
My lord, again, I beg to mention at number 16, my lord. 16, my lord, we have not yet received Paraguay's comment, my lord. I've taken consent from the petitioner side also, my lord. This matter will be released after 3 weeks, my lord.
You are for the 16th?
No,
I've taken consent from the petitioner, madam.
With the consent of the other side. The learned standing counsel, Mr. T. Tagun, submitted that they have not received the Paraguay's comment from the department concerned and accordingly needs some more time to file the written affidavit in opposition after getting the instructions, after getting the Paraguay's comments from the concerned department. Prayer allowed, this matter is any after.
After 3 weeks, madam.
Least after 3 weeks.
Deeply obliged.
my lord, I beg to mention item number 25 on behalf of S. Chakrabarti for adjournment today.
25 on behalf of
Yes,
S.
S. Chakrabarti. So matter may be fixed on 22nd July,
22nd.
22nd July.
Or in this matter also, I also appear on behalf of the state. Since the other matters are fixed on 22nd, my lord, let this also come up on 22nd.
Otherwise, S. Chakrabarti is also for the respondent side,
Private risk.
private respondent.
I'm appearing for the state.
With the consent of the other side, the learned
Obliged.
Mr. So appeared on behalf of S. Chakrabarti, paid for an adjournment. Stating that due to personal inconvenience, he is not in a position to argue the matter. And Mr. I. Chaudhary, the learned Advocate General, submitted, also raised no objection in that regard. List the matter on 22nd. Okay, it will be on.
Obliged.
Yeah, please, Your Lordship. I beg to mention item number 12, Your Lordship. Here the state has filed their affidavit, Your Lordship. So I would like to file reply against that said affidavit in opposition.
Till date, whether they have filed their affidavit,
Yes,
State-
state has filed.
already filed.
Yes.
Item number 12, heard Mr. A.K. Singh, the learned counsel for the petition. It is submitted by him that he needs some more time to file their affidavit in reply against the affidavit in opposition filed by the state respondent. 2 weeks will do,
After vacation, Your Lordship. that-
list accordingly after vacation.
Lordship.
Yeah, please, my lord. But I beg to mention one bail application, number 55 of 24.
Bail application.
Yes, my lord, as
Bail
unlisted. my lord.
matters.
Actually, my lord, the issue is that this matter was listed before the honorable bench of Justice Kardagite yesterday. So he has recused himself from hearing this matter. He has recused himself, my lord.
Why?
So maybe due to personal difficulty, so we'd like to withdraw this matter because there is a one notification which states that all the bail matters which was decided by the particular bench with regard to the same FIR, we have to the bail should be filed before the same court
It was earlier decided by this.
by the Honorable Judge K. Goswami. It's before the principal bench. So it may be taken up today as unlisted. I will withdraw the bail application.
I'm just not following you.
With the,
The questioning you, the bail matter was fixed yesterday.
yes, my lord.
That was the Mr. Kadakiti
Yes, ma'am.
refused anyway.
Yes, my lord.
So now this matter was disposed earlier by Mr. Goswami,
Yes,
Justice
ma'am.
Goswami.
Yes, my lord.
You have to file before the Justice Goswami only. It
Yes,
will be
ma'am.
listed before Justice
Yes,
Goswami.
so we like to withdraw this bail application with the liberty to file the fresh before the appropriate bench. My lord.
Now, you want to withdraw this one
Yes, ma'am.
today?
Yes.
Please.
Obliged.
Mayor, Your Lordship. Mr. I'd like to mention item number 17 on behalf of AC
Item number
17.
Ah.
On behalf of AC Sharma for the petitioner.
SS Sharma,
AC Sharma.
SE Sharma,
AC Sharma.
S Sharma,
AC Sharma.
AC Sharma. acha.
Yes, Your Honor. Your Honor, may kindly
He
fix
is
this.
for the petitioner side.
Yes, Your Honor.
He is not present today.
No, Your Honor. He's from Assam, so he couldn't appear before the Honorable Court, Your Honor. So this
You
matter
are
may be
Mr.
H. Thai.
Or Mr. Istak appearing on behalf of the NK's counsel, Mr.
Yeah.
AC
Yes.
Sharma.
Your Honor, this matter may be listed on 19th of June.
And he submitted that due to some personal inconvenience, the NK's counsel, Mr. AC Sharma is not in a position to appear before the court today. And accordingly paid to list the matter on 19/6,
19th of June. Yes, Your Honor.
19th of June,
Yes, Your Honor.
list accordingly on 19th of June.
And Your Honor, one more item, item number 20, same.
Number
Item number 20,
20.
20, yes, Your Honor.
In this case also, Mr. AC Sharma is appearing,
Yes, Your Honor.
19th of June, go back order. Have you taken the consent of the other side otherwise?
Yes, Your Honor.
Have you taken consent of the other side?
Yes, yes. Obliged.
19th of June,
Yes,
for the matter.
obliged.
My lordship, your lordship, I beg to mention item number 21. And this matter is pertains to demand of surface takes by the opposite respondent parties. And today, the engaged counsel, my senior, his advocate Rohan Shah, he's from Mumbai. He was supposed to appear through BC. However, we have informed by the opposite party that the DSGI, Mr. Kato, is also out of his station. So I prepare adjournment. And your lordship, kindly continue the interim. There is interim order. And kindly accommodate the date fixed on 27th of 7, 2024.
Mr. Kato is for the respondent.
DSCI. Yes, your
He
lordship.
is not present today.
Not present. He's out. And I have
And-
taken consent from him, your lordship.
And you are seeking adjournment. Now, who is the engaged counsel?
Rohan Shah. Rohan Shah. He's from Mumbai, your honor.
Rohan Shah.
Shah. Kindly
He
fix
was
on
supposed to appear through
through BC. Yes, your lordship.
But then what happened?
As we have been informed through by the associate junior of Mr. M.
Kato.
Kato sir that he's out of his station. So I prepare adjournment today. Kindly fix on 27th of 7/24 of this next month.
Third MS so the learned counsel appearing on behalf of Mr. R. Saha, who was supposed to Sagane Saha to Nampu Lulova, who was supposed to appear through VC, but as Mr. M. Kato, the learned as VSGI is out of station. The matter, it is paid for adjournment of the matter today. You want, what is the fixed date you want?
27th of 7, 2024.
27th of June.
June, yes.
It's a Monday.
Not this month, next month, July, on July.
27th of July.
Yes, sir.
27th of July is Saturday.
This Saturday.
Yeah.
Then Then 26th
26th of July.
July.
Okay. 26th of July.
Your interim may be continued.
Interim be continued till next date of this.
Obviously.
My lord, on the last occasion, this honorable court has asked me to get instruction as to whether the police department has been allotted the plot of land which the petitioner is claiming.
Yes.
My lord, I have the instruction.
Hmm.
There is a allotment order of 2012 itself,
2012.
12. Their entire case is that this has not been allotted to the police
Police
department.
department.
My lord will find it's serial number in the next page, serial number 11,
Hmm.
last
Police department.
Mangio. Police department Mangio, total area is 4,422 square meters for police station.
Square meter for police station.
Yes, madam. Both these writ petitions, item 2 and 3, is on the entire footing that there is no allotment to the police department,
Police department.
and they are in occupation. Now they don't have any right, madam. So they
What
cannot.
to say?
Lordship, we have gone through the RTI. So I have annexed my, that's page number, writ petition number 215, item number. I give it.
Your item number 2.
Yes, yes.
Page?
So page number, Lordship, 31, annexure 7, in 2000, Lordship, 20, I along with one of my co-petitioner has filed one RTA before the ADC Sagali concern official. And thereafter, Lordship, page number 32. Again in 2024 also, Lordship. We have filed RTI seeking that's allotment along with the that's sketch map. Only after filing these two RTI, Lordship, page number 33, we received only this copy. That's a sketch map, no allotment. So if necessary, Lordship, next time, Lordship, I will file this RTI that's form which I have already filed before the.
I have supplied him.
No, you have, when you have filed your RTI, what was the reply from the RTI?
Reply is only they have having only sketch map, Lordship, no allotment. That's why I filed the writ petition for our court, Lordship. And moreover, I am not claiming entire land, Lordship. They have encroached my land. See the condition of my house, Lordship, page number 30. Page number 30, 29, 28 to 30, Lordship, see the condition. Every farmer, Lordship. They have forcefully brought their JCB vehicle from some, that's a private farm. It's going to fall down, Lordship, in rainy season.
Now you claim the land,
I'm
you are
not.
possessing the land on what strength?
I'm possessing my land almost now 21 years, Lordship. Now thing is that they have conducted meeting, everything, but I have no knowledge, Lordship. So only I come to know from this eviction notice, Lordship. In that connection, 3 times I have already given representative to the concerned official, Lordship. But
Now from your RTI application.
Yes, Lordship.
This
Only
sketch map is
sketch map.
already provided.
No,
Now you
no.
want any information from the RTI or what?
RTI, Lordship, they said that they have only this sketch map, Lordship.
They do not have any allotment out of.
Yes, exactly. Because of that, I
But
filed
this
this.
is the order of 2012 itself.
Yes.
What the state has provided is the order of 2012.
When there is a sketch map, obviously there will be allotment
Lordship,
order.
this is now I come to very shocked that now I come to know that they have. But why they have not punished this RTI? I have applied 2 times, 2020 and 2024, Lordship.
So you want to, you need any instruction, otherwise,
I will, Lordship, take
Petition is-
instruction, Lordship, I will take instruction. After that, I will collect that my RTA form from the concerned office. I will place before this honorable court to bring out the truth, Lordship.
My lord, we under instructions, we are providing the this allotment order.
That's their part, but my part.
Their only case is that they have been provided with only the sketch map.
sketch map only.
When there is a sketch map, obviously there might have been a
After
allotment
filing-
order.
after-
Maybe in the RTI, the allotment order was not provided. but that does not give him any right to claim over the land.
Lordship, I applied everything regarding this. Their police is, the government is claiming their land. So I have already applied RTA before the concerned office that land allotment and sketch map 2 times, but only government has furnished only sketch map and written no RTA
Yes,
and no
obviously,
allotment.
but the question is that this is the allotment order in 2012 itself from the police department. Apart from that, now what do you want to procure from the RTA by making an RTA fresh? Do you need any time, some more time?
Yes, I need time.
But what is the issue? I mean,
But
I need time.
in any
I-
case,
there-
in
I will make
in any
clear it,
case,
Lordship.
he'll have to establish his right over the land.
yes, so.
Yes, obviously that can be, but
Obvious.
Lordship, I will take instruction from my client and I will file some other.
Yes.
Very surprised.
Heard Mr. T. Tapune? Huh? T. Tapune? T. Tapu, the learned counsel for the petition. And also heard Mr. N. Ratan, the learned additional advocate general, appearing on behalf of respondent number 1 and 4. In pursuant to order dated 31/5/2024, Mr. N. Ratan, the learned additional advocate general, has furnished the allotment order for the police department, which was an allotment order seems to be issued on 23rd of July 2012. In this context, Mr. Tapu, the learned counsel for the petitioner, submitted that he will get more instructions from his client, as they were provided only with a sketch map, while by the which they received through RTI, and hence he has no knowledge about any allotment order on behalf of the police department. Mr. Ratan, there is no objection in this regard. Let the matter be. You need
2 weeks, Lordship.
2 weeks.
Yes, there my client is in village area, not in capital.
Is the matter
Tell it,
accordingly,
Monica.
is the matter accordingly after 2 weeks, and
Lordship,
the petitioner side to get the instruction from the client and to file get the instruction from the client. Yes.
Lordship, that interim order may be continued. That's
What's
on
the interim order?
31/5, that eviction order was
Now see, it is the police department has already been allotted land and they're working, and so it will be continuing, then it will affect.
that
My lord,
interim order
therefore,
21/11.
interim cannot be continued.
Lord-
No. Interim was given only for to the
Yes.
effect that whether there is an allotment order to the police department. or not.
Just for 2 weeks, Lordship.
If it is continued, then definitely the
Yes.
work of the
Yes.
construction work will be hampered. Anyway, okay then, this after 2 weeks. Till then, we interim is, okay. Interim may be continued till next.
Only in respect of his house,
Only in respect only in respect of his house.
Obviously.
House and land also is there, no?
Yes, house and land
House.
included.
House and land, okay.
We are not claiming entire land, Lordship, only my portion.
Now see,
And similar, Lordship.
on what strength you are
My lord,
occupying.
my
yes,
only
yes.
house, only house, my lord,
Item of
only house.
procedure.
Otherwise, he will again stop the entire work. His house, okay, he is residing, will not
Yes,
evict
yeah,
him.
that's what only
That-
we have already.
In respect of house. we don't
Only
have-
house,
Lordship, item number 3, same.
same.
Same. Item number 3 also, no?
Yes.
In item number 3 also.
Same.
we-
Same.
2 weeks corridor, till then, the interim order be continued in respect of the house of the petition.
Always.
Oh.
Much of.
Item number 4.
Right, please, Lordship.
Yes.
My lord, here, the petitioner, my lord, is got water connection, my lord, from the PHE department, my lord. But on the behest of respondent number 4, respondent number 5, he lodged a complaint saying that why water connection should be given to this person, my lord. I'm constructing a building, and next day, my lord, the department comes and disconnects the water, my lord. Now, Lordship, your Lordship is aware, my lord, Government of India has launched this scheme, Jal Jeevan Mission, my lord. And it envisages that every household should get water connection, my lord. In this water connection is already there, my lord. I was given water connection. On behalf of respondent number 5, it has been disconnected, my lord. I have filed representation, but
Respondent number 5 is also resident of that locality?
yes, my lord. But how, my lord, why should the authority act on behalf of some individual, my lord? They should apply their own mind, my lord.
How can you come to know that it is only?
We went to the office and because we filed a representation, my lord. They said this, because of complaint, we are not giving you reconnection. Lordship, page 13 and 14, these are the representation which we have submitted. As of now, we are praying that notice may be issued, my lord. Page 13 and 14, my lord. This is the representation which we have given.
This is the representation given by the
Which-
respondent number 5.
No, which we have
Okay,
given.
okay.
After, I don't know how he can order the authorities to disconnect my water supply, man.
Yes, Mr. Rela. You are appealing for 1,
1 to 4, your lordship.
1 to 4.
Yes, we'll take steps on respondent number 5.
Heard Mr. Tito for the learned for the petition. And also heard Mr. Y. Ridham, the learned government advocate appearing on behalf of respondent number 1 to 4. This is an application under section, under article so and so, so and so. Issue notice to the respondent number, no formal notice is required to issue against the respondent number 1 to 4, as the learned government advocate had already appeared. However, extra copy to the deliver. Issue notice to the respondent number 5 to register AD and as usual process. List accordingly, it will be listed after 3 weeks.
Yes, 4 weeks, my lord, it's a
4
bit far.
weeks. List after 4 weeks.
Obliged.
Item number 5.
Please, your lordship.
Yes.
My lord, the writ petitioner had previously filed another writ petition, WPC 93 of 2024,
Hmm.
challenging certain conditions in the NIT, which was floated on 20th of February 2024. At page 53, your lordship will find the order passed by this honorable court in that proceeding. The writ petition is still pending, lord. Page 54, your lordship can come to the first paragraph on fourth dated 2024. Now the notice was issued, and in the operative part, your lordship will find the next page, the third paragraph. In the interim, it is directed that the respondent shall receive the bids in pursuance to the NIT dated so and so, and shall process the same on its own merits. However, the award of work shall not be effected without leave of this court. Now, after this was passed on 4th of March. After this was passed, my lord, the impugned corrigendum has been issued, which is at the next page. And by this corrigendum, my lord, the conditions have been further made stringent. So the writ petition 93 is pending, my lord. This is only by way of challenging the subsequent event. So my submission at this stage will be, your lordship may also issue notice in the matter. And as the interim order has been passed in the previous case, my lord, similar order may be passed here also, that without leave of the court, this corrigendum shall not be acted upon.
My lord, may I have some objection. This matter, writ petition number 93, it is fixed on Monday, 10th. So this matter can be clubbed together and be heard together. Because, my lord, in the writ petition number 93, we are the party. We are party respondent number 3. We have categorically taken the state, my lord, in our annexure 2, my lord, that there is a corrigendum. And in that respect, we have filed an IA, my lord. Now, we are party there, but in this writ proceeding, my lord, we have not been made as a party.
No. He is mistaken, my lord. In that proceeding, my lord, they were made only pro forma parties. They came out of their own volition.
No.
That was not the case. I can produce the order, your lord, subsequent orders also. They came out of their own volition. No relief has been sought in that petition as against them. And surprisingly, despite being a pro forma respondent, they want to come into the picture. We said nothing. If you want to come, you can come. This is only a corrigendum which the state has been issued. State has issued. If something has got to be said, it is for the state to say. What is his locus in this case?
My lord.
He does not even have any locus in the writ petition 93. But only because of the fact that his senior made a submission that he wants to be interested in the matter and he wants to make some submissions. That's why it was allowed. He does not have any locus in the case. If he wants to object to it, let him file an application for impleadment and thereafter your lordship will
No,
see
my lord, this
what is
writ
his
petition
locus.
may be
locus.
in that case, my lord, writ petition may be dismissed for non-joinder of necessary party because entire facts, my lord, same facts is pleaded in that case. Only the corrigendum, my lord, which is now new, my lord. And corrigendum part, we have categorically taken our statement, my lord. And annexed it in annexure, as annexure 2, my lord can see, my lord.
My lord,
It is
today,
there, my lord.
today, my lord, my
Can it be
submission
taken
is
out
that
tomorrow, my lord, Monday, my lord?
this,
Monday only.
this writ petition is coming up for the first time today. In this writ petition, he is not even a party. So he does not have any right to make any submission before this honorable court. And it is up to your lordship and of course my learned friend appearing on the other side, whether or not your lordship will issue notice on the matter. He doesn't have any locus. How can he even open up his mouth? The other writ petition that he is referring, your lordship can call for the record that I can show your lordship at 2. He is only a pro forma respondent there. No relief has been sought against him. What is his interest?
Entire facts is same, my lord.
He may be one of the affected party. or-
No,
Yes,
no.
yes, sir. I am a participating bidder, my lord.
That's why, my lord, I am saying if your lordship wants to verify my submission, your lordship can just call for the records of the 93. Your lordship can take up this writ petition after some time. I will show. He is a pro forma respondent there.
Monday, my lord, Monday it can be taken. My lord. I am representing on behalf of Diganta Das, sir, my senior advocate, my lord. On his instruction, I am appearing, my lord. Because the issue is same, my lord. Only the corrigendum part, it is new, my lord. Everything is same, my lord. And we have taken the stain, my lord.
Corrigendum part is new, means that means they are challenging the corrigendum part.
Yes, my lord.
Now.
But, my lord, the other facts also are there, my lord. And in that
And
my lord,
in
context,
that-
my lord, we are
despite-
respondent. We are
yes.
respondent number 3, my lord.
And despite, that's why I am saying, my lord, if your lordship wants to verify my statement, please call for the record of 93. Your lordship will see, despite they filing an application for vacating stay, my lord, the stay order is still continuing today.
It is fixed on Monday,
It
my
is
lord.
still continuing today. So what right has he got
Which
to
is the
make
date
a-
fixed on the earlier matter?
the
Monday,
earlier
Monday,
matter
my
is fixed on 10th of this month for the purpose of
Today is Friday, my lord. Next Monday, my lord.
completion of pleadings, because there are other 2 writ petitions, my lord, where the pleadings are yet to be complete. So therefore,
My
and
lord-
in other 2 writ petitions, my lord, why this writ petition has been necessitated. In the other 2 writ petition, my lord, this corrigendum has already been challenged by way of an amendment. And the amended writ petition is pending for consideration on 10th of March. It is another writ petition. Now today, since there is already an amendment in a connected writ petition, my lord, unless I also make the similar prayer, my lord, the petition may become infructuous, my lord. That's why this amendment application, this petition by way of an amendment has been made. Now today, he doesn't have any locus. Your lordship will kindly see who are the parties. If he wants to say something, let him file an application, be a party here, and thereafter your lordship will see.
My lord, we have not been made deliberately as a party, my lord.
You are not a necessary
Because-
party. Why should I make you a party? Because the relief is sought against the government, not against any private party.
Everything, my lord, every fact is same in writ petition number 93, my lord.
My humble submission is this, my lord. Since there is an order, similar order passed in the similar case, and the case is pending, it is not decided as yet. Your lordship will kindly issue notice on the matter. And as it has been passed in the other case, my lord, similar order may also be passed. If he is otherwise interested in the matter, he will file an application and come in.
I
That
am
your
an
lordship will see.
interested bidder, my lord. I am a necessary party, my lord. In that case, my lord, this writ petition may be dismissed for non-joiner of necessary party, my lord. My lord, may please fix this matter for Monday, my lord. It is today Friday. Today is Friday, my lord. Saturday, Sunday, Monday, my lord. It is only 3 days, my lord. Here. On Monday, it can be disposed of, my lord. Or notice may be issued, interim may be considered. That would be a different thing. My senior will appear, my lord. 10, my lord. Monday, my lord.
Can will be sufficient.
My lord, my submission is that he is not a party. Why your lordship should hear him? If he is a necessary party, let him show which part of the writ petition affects what right of his. Let him show now, or otherwise your lordship can call for the records of 93, take up the matter after some time. I am sitting here, my lord. Let him show what right of his is affected. It is only on the instance of his senior's submission that he is interested in the outcome of the proceeding. The honorable court had allowed him to make submissions. Your lordship can verify the statement from the record. I am making a bold statement at the bar. My learned friend is also there. He also knows the fact. He has been made a pro forma respondent in the party. What right a pro forma respondent has got in a proceeding? Unless and until some relief is sought against him, a pro forma respondent has got no right.
93 at a-
Any order,
Lordship
my lord,
will
will
bring the
affect
records of
me, my lord.
93?
Because I am a participating tender, my lord, bidder, my lord. It will affect me, my lord. Because the tender process will halt, my lord. I am a necessary party.
Matter to, I think after some time it will.
At 2,
Yes.
my lord, at 2.
No, your lordship it may be brought now, my lord. I am waiting, my lord. Your lordship can verify my statement.
In case my senior can also appear by VC, my lord, that's why on 2, at 2, my lord.
2.
Yes, my lord.
Okay.
Obliged.
It will search the WPC 93 at PSA. Search it for one then. At 2.
My lord, if this matter can be taken up after 2 weeks, my lord, I pray.
Yes.
Because this will take time, my lord. There are various issues involved. The rights of the forest department, the individual rights of the petitioner. And there has to be a stand taken by the government, because this is for acquisition of land for this power grid. Now, it is petitioners claim that it is their private land, community land. It has not been reserved. It's an unreserved forest. Now, forest department claims that this is, although this is not a reserve forest, but it comes under forest, definition of forest, they are the one who has to be compensated. So this will take time.
Yes, Mr. Patil.
Matter may be admitted and after the matter posted for final hearing.
Pardon?
Final hearing. Matter may be posted for final hearing.
Final hearing.
For final hearing.
This may be admitted and fixed for final.
He is appearing on.
I am power grid.
Yes, yes. Power grid.
Restriction number 9 and 10, Lodge.
Yes, 9 and 10. Mr. Parmi is for power department.
State power department. It's for state power, Mr. Patil.
No, he don't.
So for, is there any appealing for the forest department also? No?
Yes,
They
madam.
come in
I'll appear for 4 to 8
4 to
and-
8, na?
and 11.
I am for one entry, my lord.
For land management.
Land management.
Land management is, respond number
1 and 3.
1 and 3.
1 and 3.
Yes.
I am for 2. I am for
Yeah, 2.
Interesting. Yeah.
I am for 9 and
Do you
10.
have any objection in where we may admit the appeal, admit the petition, and it may be listed for final hearing? That's what they are submitting.
My lady, it may be done, Lordship is of the view, but again, Lordship, here there are two issues.
No,
The-
issues will be that subsequently, but they are seeking, Mr. Ratan is seeking some time. Let the matter be admitted and it may come up for final hearing then? In
Yes,
that case? Okay.
yes. Lordship, on the 26th of June, 24th of June,
Okay,
Not-
we are trying to.
Not on 24th, madam.
Maybe after vacation.
Maybe after vacation, madam.
after vacation,
Yes.
Yes.
Lordship,
Mr. Yes,
17.
heard Mr. K. Kamtu, the learned standing counsel for the land management, for the respond number 1 and 2. And also heard Mr. L. Parme, the appearing on behalf of respond number 2, Power Grid Department. And Mr. N. Ratan, the learned additional advocate general for the respond number 4, 5, 6, 7, 8, and 11. And Mr. N. Khera, the learned standing counsel for the Corporation of India, for respond number 9 and 10. Agote Mukpatin Didi Bamnam to senior advocate, assisted by K. Dabi. First for the heard Mr. M. Patil, this is the senior advocate, assisted by Mr. Suez. It is considering the submission made by the learned counsel for both sides. Matter is admitted for hearing. List the matter for final hearing. Yes, you are saying 24th?
No, after vacation.
17th
After
of July,
vacation? After
17th
vacation,
July, 17 July,
17 July will do,
July.
17.
after vacation.
it's after vacation.
Yes, my lord, no issue.
July 17. Yes.
Okay, then it will be fixed on 17th of July.
Yes, yes.
Admit proceedable 7th of July for final. Okay.
I will make it prayer for disposal of the matter today, because the matter is otherwise very simple matter. My lord, the husband of the petitioner was a government employee. He belongs to police department.
Government employee.
I'm government employee, belong to police department. IRBN, which is a department of government, my lord. Then, my lord, he died while discharging his official duties. In the meantime, government, my lord, issued a notification saying that any person died in course of discharging official duties, he is entitled to get, my lord, 50 lakhs of compensation. And accordingly, my lord, in terms of the state policy decision, my lord, legal heirs of the deceased government employee approves the government, made an application. And as per the policy decision, there are two different committees, fact-finding committee and approving committee. The fact-finding matter was referred to fact-finding committee, district level committee. District level committee, on the basis of recommendation made by my lord department, parent department, as well as the department, my lord, district authority, district inquiry committee, matter was referred to government. In holding that, my lord, he died in course of discharging his official duties.
Yes.
And thereafter, my lord, all on a sudden, my lord, without giving any reason, my lord, Home Department, 2 and 3, they arrived at a conclusion that petitioner died during the COVID period. Therefore, his death was caused by COVID. Therefore, he is not entitled and covered by that decision. But the facts remain that, my lord, he was allotted with certain duties. He performed his duties while returning from, my lord, from the place of, my lord, deployment. He died of accident. But the question is, my lord, whether my lord, death caused by accident in course of discharging official duties, will it covered by this notification? And my lord, they filed affidavit initially. Court was not inclined to accept this affidavit. Court says there is no reason whatsoever. Then they filed additional affidavit and twisting their original stand. Initially, they said death was caused by COVID. Therefore, it is not covered by notification. Subsequently, they took a stand. Accident is not covered. And there are a number of decisions on this point by various high courts, including, my lord, I have, my lord, compiled certain documents. In our affidavit, reply affidavit, we have specifically stated that, my lord, in an earlier occasion, my lord, one police official was died of, my lord, air crash.
What is your ground of rejection? He died out of COVID.
They said he died of COVID. But I was never died of COVID. I was allotted certain duties for performing during the COVID period. Therefore, Lordship will examine this question, and our case is squarely covered by that decision. District level committee, my lord, arrived at a conclusion recommending our case. SP also recommended our case. And now they, my lord, took a turn, saying that no, since he died of accident, now it is not covered. Therefore, whether accident is covered or not covered, it will be exclusively, my lord, it can be ascertained from the notification itself. Once it is not included, how can you bring it within the purview of this notification? One page 134. My lord, Lordship will find I have given the typed copy, page 138. May I read, my lord? On the other hand, my lord, we took a positive stand in our reply affidavit. Since COVID is declared as, my lord, disaster, national disaster. Therefore, my lord, even if a person died of, my lord, COVID, then he will covered by last category, disaster management duties. If you say that he was assigned with COVID duties, then also he will covered by last category, disaster management duties. Therefore, there is no any question or no any occasion for the government to exclude the petitioners from the purview of this notification. Yes. And whether Lordship will, my lord, hear the entire matter today, or I don't know, my lord.
They are also ready. I think.
My lord, this will also require time, my lord, because whether their category, he, while performing COVID duty, while returning back, he met with an accident, and while performing duty, while returning back, he met with an accident and died, my lord. Whether that can come under this notification. It is not that simple. Otherwise, every sort of on duty will have to be be paid under this notification.
The first of all, Lordship will ascertain
We
what
have
was the
given-
duty.
we
Whether
have-
duty was pertaining to COVID or duty was regarding his official duties. There is law and order duties. Report is absolutely clear. They took a stand that he was allowed with COVID duties.
Yes.
He doesn't belong to, my lord, a medical department. He nowhere connected with the COVID team. And he was allotted for discharging law and order duties. There is a report.
No, I
submitted by
During the
District Level Committee.
COVID time, my lord will remember, even the police personnel they were given duties for COVID duties, my lord.
No,
Law and
this is
order
not the
duties.
COVID duty. You
COVID
just-
duties, my lord.
Lordship, kindly have a look, my lord.
Some of the police personnel were entrusted for COVID duty also. That is.
Yes, yes.
No, our case is not COVID
No,
duty.
your main case may not be
Yes.
there, but the otherwise also there were some duties.
Then, my lord, if it is so, then Lordship will come to the conclusion that it is a disaster management duty. And notification says disaster management duties is one of the category. And Delhi High Court says, my lord, even if a person is allotted with COVID duties, but if he died during that period, then he is entitled. 1 crore compensation was granted. That decision is with me, my lord. First of all, Lordship is to look into the report. Because fact-finding report, as well as the report submitted by the department, as well as the order. Order to go. Therefore, my lordship, I will suggest that let the matter be admitted. And lordship may fix the matter on 22nd. And on that day, my lord, matter will be hard.
If only matters are fixed at 22nd, it may not be possible in the court for the part of the court to
Yes.
hear
My
all
lord,
the matters.
I'll just take your lordship to page 188. Why? That's why I was requesting, let the
Yes.
health department file.
Health department is not a formal.
No, why not, my lord? Page 188. Page 188. 88. This is a letter by the Joint Secretary Home to the Secretary Health and Family Welfare. The case of the petitioner and one other, their case has been referred to the health department because they were performing COVID duty. If they, at that point of time, the government of India, they had certain notification for those persons who died in COVID duty. Now, therefore, if the petitioners can be considered by the health department, that is how the home department is written. Now, they don't want the ex gratia from the health department, the COVID time. They want from the state government notification only. That is the whole thing, madam.
My lord, lordship,
So this
kindly have a, I'm sorry, my lord, for interruption. Lordship, kindly have a look, just one line, my lord, 184 page. What is the report says, what is the, my lord, communication made by SP? SP is my department. And he is the best person to say what sort of duty was allotted to him. They can't say.
Cause of death, yes.
At page 184. Have a lordship got, my lord. What is the basis to say he was allotted with COVID duties? No basis, nothing of the sort. It is mere presumption.
It is
Since it was during the COVID period, so person was allotted with COVID duties. It is not that. Page 184, annexure 14, I am referring para 1. Happy Lordship Court, my lord. I'll read, my lord. On 12/5/2020, at 18:30 hours, an information was received from OC Shantipur check gauge to the effect that Captain so-and-so, 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 along with one section of personnel from decoy so-and-so, so-and-so deployed at rowing had met an accident while returning from duties as being rushed to the district hospital. Then Lordship kindly come. Para 4. From the investigation, it has established that the section of force from decoy 5 IRBN is the one of the department covered by this notification. Deployed at Shantipur was entrusted with responsibility of patrolling in the yard, in the area to prohibit illegal trespass. So what is the question, my lord, to COVID duties? In the district from Assam, in view of COVID-19. In view of COVID-19, there might be some migration, my lord, or some wrong entry. So to prevent this matter, all this thing, he was allotted with law and order duties. That some miscreants from Assam are trying to enter through porous boundaries by passing the terminal screening, etc. procedure. Therefore, from this particular, my lord, contention, it appears that he was never allotted with any COVID duties. And other days, my lord, submitted before the court, even assuming for timing, if I accept their contention that it is nothing but a COVID duties, then also, since COVID was declared as national, my lord, disaster, not only by the central government as well as by the World Health Organization, and therefore it will come under disaster management duties. And if it is a disaster management duties, then it is covered by that notification. So this is the, my lord, factual background. Some argument is necessary. They raised a question. So Lordship may admit the matter and fix the matter for hearing on 22nd.
If you go by the para 4, that now here we have submitted.
Yes.
In para 4 also, it is seen that he was engaged some COVID duty only.
No, in view of COVID restriction.
Yes, there was some
It is not at all, my lord, related to COVID.
No, some miscreants from Assam
Yes.
was trying to enter. So that duty was he was engaged in.
Yes.
My lord, last
That is
page
COVID.
of his own petition, my lord, page 189 is clear. Last page of his own.
Last
petition.
page, there is the views expressed by the Home
Yes.
Department.
That is the statement of the disaster management also. Cause of death due to motorcycle accident while returning from COVID duty at Santipur check
It is
gate.
their views, my lord. That way of challenge.
No,
They have to
they
justify-
are,
they have to justify how can they constitute to be COVID duty.
Yes, from the department.
And my lord, if it is a COVID duty, then it will come under the category of disaster management duty. I'll show my lord authority.
so let it be admitted and fixed for hearing, my lord.
And he was declared as a martyr. Hello, can you see? We have given the list. A person who was declared as a martyr for the whose, my lord, sacrificed his life for the state, my lord, for the sake of the people. And you are not, my lord, granting his extension. His wife is doing, my lord, manual labor. Page 11 of compilation, my lord, Lordship kindly say, item number 71. Declared as martyr. It is your own document, my lord. It is your own record. Casually, they have come to the conclusion COVID duties. How can it be a COVID duty? It is absolutely and purely a law and order duty.
Mr. A.K. Purkast, when it comes. When it comes for the petition, also have Mr. Your health department is for which petitioner?
And for respondent 11.
11.
Yes.
And also heard Mr. Anderton, the learned additional advocate general, appearing on behalf of respondent number 2 to 10. And Mr. T. Dragon, the learned standing counsel for the health department, representing respondent number 11. Is
Health
seconded by
department
Mr.
took time more than 3 times, I think. So, my lord, kindly appreciate our problem, my lord, our hardships.
No, if the other side is ready, I'm ready to hear. It's not a question of.
Yes. And page number 12 of my compilation, my lord, I can show your lordship apprising the court that one person died in a helicopter crash. He was a constable and he was given a compensation of 50,000, 50 lakhs. And he also belonged to IBRN,
This is an
IRBN.
It's an application under Article 226 of the Constitution of India for issue so and so corrective. And against. And the petition submitted that the application has been filed again for the violation of legal and constitutional and fundamental right of the petitioners as being the legal heirs of the deceased government's employee, bracket of police personnel, who was supposed to give the ex gratia compensation as being the part of the means of livelihood as guaranteed under Article 21 of the Constitution. Considering the submission made by the London Council for both sides, the matter is admitted. List accordingly, even the 22nd may not be possible, 22nd of July.
My lord, otherwise, I'll have to come once again, my lord. 22nd.
In the
Otherwise-
month of July, it will be possible? Yes, sorry, in month of June?
Month of June vacation, my lord.
No, in July, not July, month of June.
June, my lord, possible. I'll go out of station for my treatment purpose.
Let it be on 22nd, yes.
We will make an
Second,
endeavor,
already we have fixed 4-5 men.
Yes, my lord.
Already for Mr. Prakash only.
my lord.
So if it is possible, then it's okay, otherwise.
It is only on that day, how many cases you'll
Yes,
like to
that's
do.
what I'm saying, that's what.
That, your story is absolutely right. Otherwise, it may create
If
for
it is, suppose, in that case, if you come by, not
then I'll have to come for 2 days.
immediately after vacation, can it be possible? Immediately after vacation, in the month of July itself?
Vacation,
Most of the cases we have already been fixed on 22nd of July, so let it be on 16, 17, 18 July and on.
lordship, kindly consider my prayer. Let it be on 22nd. If necessary, I will make a prayer for
The next day.
for accommodating for the next day.
Next.
Okay.
I will stay back. my lord.
22nd. Okay.
On the other hand, my lord, I would like to point out one thing. The initial stand is COVID, as my lord, my friend referred to. They also filed affidavit, my lord, my lord, so to say, my lord, supporting their original stand. Then they filed one additional affidavit. Now they twisted from the original stand, my lord, saying that since it is a death was caused by
they're saying
accident.
now they are saying then if it is suppose he died under the COVID duty, then in that case also he may be entitled from the health department. What is the harm? Do we have
That's
any
right.
objection in that case?
That's no, my lord, what I am pointing out, my lord, initial stand is COVID, subsequently they twisted from their own stand. Now they are saying, since the death was caused by accident, that it is not covered. That is their stand. That original stand goes.
Obligement.
Obliged, your lordship.
Item number 10.
Obliged.
Can we give this your compilation today or you are going to submit in the next day? Otherwise, it will be on with the record only. Just now we have submitted the compilation. Yes, you have submitted the compilation, can I? No, compilation you have submitted. It will be on with the record or you want to get it back? Okay, okay. Yes, item number? Yes.
Yes, ma'am. Well, here,
That competition was submitted today, and that will be kept as a part of it.
Okay. Okay.
ma'am. Well, here, this responding authority, this Orchid Corporation of India, while constructing the transmission tower in the top of hill above my house my house has been totally destructed due to siltation and erosion while constructing their transmission tower. So accordingly, I submitted a representation to them, and they have referred the matter to additional deputy commissioner, being the government authority, to verify the actual losses. Accordingly, a committee was constituted and assessment report has been prepared. Then they sought approval from deputy commissioner. Deputy commissioner has approved. And finally, they sought my bank account details. After submission of bank account details by the additional deputy commissioner, they have not released the loss assessment report submitted by ADC. So
Otherwise, they have already assessed your loss.
yes,
Loss has already been assessed.
they have directed the additional deputy commissioner to assess, and they sought deputy commissioner approval. Approval also be given, and even this they have sought my bank details also. I have submitted bank details. Thereafter, they are not releasing this compensation amount. So I'm seeking direction to direct them to release the loss assessment report prepared by the additional deputy commissioner.
So, please, where you have annexed your
Yes.
assessment, etc., anything?
And when I come to page 27 of my petition,
37.
27. This is the letter written by the Power Grid to the additional deputy for preparation of losses.
To seeking your account details.
Yes. Yes, 27 is. Loss assessment is on page 28.
Please,
Page 28.
20.
Yes, this is forwarding letter submitted to General Manager Power Grid by the ADC Sagali.
Page 20 or 20?
28 is the forwarding and main.
28.
Yes, 28. And 29 is this both proceeding report, loss assessment report. Well, merit this finding of the recommendation. The board of the above was viewed as damage has been due to the soil erosion considered to be caused by executing agency, that's Power Grid, Chimpu Holongi, 139 kV TI, white office number. So this is the list of loss assessment report prepared by the committee. They have assessed the loss up to 1 crore 12 lakhs approach.
So as per the assessment, it was 1 crore
1 crore
12 lakhs.
12 lakhs 33,104. And then also come to page 36 of my petition, Annexure 7. Okay. After this, the respondent power authority has sought my
bank detail for deposit of the compensation amount. Last para, kindly intimate the bank account of ADC Balijan District Secretary for deposit the compensation amount for further release of third Rajuk and his family. This one, third Rajuk is the petitioner hearing. After that, this next page 37, this ADC has submitted their account details.
Page
So-
38 is the
Yes.
releasing of the compensation.
No, submission
Page
of,
38 is,
no, not page 37.
no, 37, your bank details was.
Yes.
Yes.
No, 38 is my representation because they, after submission of bank details, they have not released their compensation. So I'm seeking for a direction to release the loss.
Yes.
Lordship, I am representing Power Grid.
Yes.
Lordship, there are certain developments and I am awaiting some instruction. What we have learned, primarily these landslides which happened, they did not happen at one particular location. It was because of the rains and an unstable hilly terrain over there that landslides took place on several places. And we have also we have learned, Lordship, however, I am still I will not be able to say it with conviction, but what I have, because I'm awaiting certain instructions, but what I have learned is that there was a relief package which was already paid to all these affected people because of the landslide, which was not in our knowledge at that point of time, and we have come to know of it at a later stage by the state government itself. So what I will pray, Lordship, at this stage is that I may be allowed to file an additional affidavit if required. Matter may be admitted for final hearing, and it may be placed on the 17th of July itself. And in the meantime, if required, we may be the filing of an additional affidavit may be open to us. Because if they are entitled, Lordship, we will not be shying away from it if they are entitled. However, it is public money, and we would not like to. We like to ensure that it is utilized in the most proper manner, since it's public money. So it may be admitted for 17th of July for hearing, and in the meantime, if it is required, we may be given the liberty to file an additional affidavit.
Yes, anything to say more? Mr. Parme, he is appearing for Power Department.
He's for state.
So he's saying that there may be some new development.
Yes.
And as per his instruction, most probably some of the affected people of the landslide has already been compensated. So let him file an additional affidavit. That's all. Hard, your Mr. Hard Mr.
K. Dabi.
K.
Dabi.
K. Tabi, the London Council for the petition. And also heard Mr. Alpami, the London Standing Council Power Department, representing
For 3.
representing respond number 1. And heard MS so the learned advocate, learned government advocate appearing for the respond number 3. And Mr. N. Khera, the Standing Council, Power Grid Corporation of India for respond number 2. It is submitted by Mr. Khera that there may be some recent development in the case, and as per his instructions, the affected people were already been compensated by the department.
Lordship, some form of relief package was given by the state.
Some form of relief package was already given to the affected people. However, he needs some more instructions from the concerned department concerned. And he paid for some more time to file their additional affidavit if required. Considering the submission made by both the parties, matter is admitted. Let the matter be listed for final hearing. Do you have any fixed date, or because 22nd July is already over?
17th of July. 17.
It be possible, Mr. Parme, 17th of July? listed on 17th of July for final hearing. In the meantime, the respondent number, here the respondent number.
Two, Lordship.
Respondent number 2 may file their additional affidavit if required. List accordingly. Okay, it will be listed.
Highly obliged, Lordship.
Alright.
My lord, this matter may be fixed for this admission hearing.
Otherwise, it is listed for in the order column.
Yes.
No, it
Yes,
is
yes,
listed for, no, in the
yes.
admission column itself, oh, sorry. It listed in order column.
Yes, my lord.
No. You are Mr.
K. Logan, Lordship.
K. Lawyer, the learned counsel for the petition, also had Mr. D. Kamduk, the learned standing counsel for the land management department, and MS so the learned government advocate for the state.
Here, my lord, respondent number 1 has not filed affidavit, but then, my lord, our affidavit is not required. We will be relying on the affidavit filed by the deputy.
You have not yet filed.
Yes, it is not required at all. So we will not be
Submitted
filing.
by, okay, it is submitted by Mr. Kamduk that the learned standing counsel management that they are not going to file separate affidavit in opposition. However, they will rely on the affidavit filed by
Deputy Commissioner.
you are representing 2,
2, 3 and 4.
2, 3 and 4.
I'm representing
Health department. Mr. So the learned standing counsel for the health department also submitted that they will also rely on the affidavit in opposition filed by the state respondent number 2. List the matter accordingly for admission hearing. After 2 weeks will do?
2 weeks.
After?
2 weeks.
2 weeks. List accordingly after 2 weeks. In
Lordship,
addition,
there is an interim order also.
interim order was
Lordship,
taken. Interim order will continue till next date of list.
Obliged.
Item number 13. Yes, 13 is in, why isn't it in order column?
May I, Your Lordship?
Get that file. You are for respondent.
Yes, Your Lordship.
Respondent number?
A private respondent number 4 and 5, Your Lordship.
You are 4 and 5.
Yes.
I'm for 3.
You are for 3. 1 and 2 is another government department or what? 1 and 2? One is state, 2 is land management.
1 and 2 land management.
1 and 2 land management, and 3 the deputy commissioner. 4 and 5 you are appealing. You have already filed your affidavit in opposition? Okay.
Your Lordship. 4 weeks time having granted for filing counter affidavit, Your Lordship.
None appears on call for the petition. However, heard Mr. You are Mr.
P. Menjo.
P. Major, the learned counsel appearing on behalf of respondent number 4 and 5, and also heard MS so the learned government advocate appearing on behalf of respondent number 3. It is submitted by MS so that they have already, the state has already filed their affidavit in opposition. Yes, you are principal deputy.
I'm appearing on behalf of Mr. D. Standing Counsel for respondent one.
So the learned counsel appearing on behalf of Mr. the learned standing counsel for land management. You have filed your affidavit in opposition, no?
Yes.
Accordingly, sought some more time to file their affidavit in opposition. List the matter accordingly after 3 weeks. Okay, you filed your affidavit in opposition after 3 weeks. The petitioner side is absent today. In that case, Okay, it will be listed in order column itself. Thereafter will be addition column. Okay. List accordingly.
Item number 14.
Uh, I have taken steps upon the respondent number 3, my lord, and by order dated 23/4/2024, my lord. The
Here,
notice
who are the other respondents, in fact?
1, 2, my lord, R. Soikia is there.
One,
He,
two,
yes. Notice upon the respondent number 3 is complete, my lord. But my lord may see order dated 23/4/2024.
one is state.
No, Information Commission, my lord. Arunachal Pradesh Information Commission.
Acha,
So 1 and 2 same, my lord.
1 and 2.
2.
Three not yet served.
3 served, my lord. It
Then?
has, the notice upon the respondent number 3 has been deemed served, my lord. By order dated 23/4/2024. I have taken justice service.
20.
23/4. Order 23/4/2024.
It was under justice service.
Yes, my lord.
Okay, then if it is already. Mr. R. Sekre is absent today.
Yes, my lord.
Whether they have filed any affidavit in.
No, my
affidavit?
lord. Not yet, ma'am.
Not yet.
No.
And you have filed your additional affidavit one.
Yes, ma'am. In respect to justice service.
Okay. Heard Mr. B. Picha, the learned counsel for the petitioner. As per order dated 23/4/2024, it is seen that service on the respondent number three is already deemed to be served. Mr. Sekya, the learned standing counsel for Arunachal Pradesh Information Commission is absent today. From office note, it is seen that the respondent number 1 and 2 has not filed their affidavit in opposition till now. Accordingly, one more chance may be given to the respondents to file their affidavit in opposition, if any. List accordingly. After 3 weeks, it will be listed.
After 4 weeks, ma'am.
After 4 weeks,
Right.
list after 4 weeks.
Obliged.
May I please,
Yes.
Lordship? Respondent number 4 and 5 is
Yeah,
yet
for
to be
respondent
filed their
number 4 and
counter
5.
affidavit. Yes, Your Honor.
No. You have for respondent number 4 and 5. Or
No. I am from petitioner.
Yes.
Respondent number 4 and 5 yet to be filed their counter affidavit.
Or yet to be filed. Acha.
Yes.
Yes. Acha, for you are representing 4 and 5.
No, only for 4.
Only for 4. And who is 5 in fact? 5. So 1, 2.
See, Lordship, I am appearing for power grid, respondent number 1, 2, and 3.
1, 2, and 3.
Lordship, we have already
You have already filed?
already filed. Lordship.
Okay. You need how many time? 4 weeks? You also need 4 weeks. You are Mr. N. Taji.
El Takam.
Huh?
Appearing on behalf of N. Taje. And my name
Mr.
is
So and so appearing on behalf of N. Taji for the petitioner. And also heard Mr. L. Parme, the learned standing counsel for the power grid. And Mr. M. Kera, the learned standing counsel for respondent for appearing on behalf of the year for 4. 1, 2, and 3, Mr. Khera, huh? And 5, represented with MSG for running, Learned government advocate, huh? 45, and Mr. Fuster, Mr. Parme further submitted that he needs for at least 4 weeks' time to file their affidavit in opposition. Both Mr. L. Parme and MS so-and-so takes 4 weeks' time to file their affidavit in opposition. In that context, Mr. Khera, the counsel appearing on behalf of respondent number 1, 2, and 3, submitted that they have already filed their affidavit in opposition. In this matter, accordingly, you need 4 weeks' time. This matter accordingly 4 weeks, enabling the respondent number 4 and 5 to file their affidavit in opposition.
Lordship, 17th of July, it'll be 4 weeks. 17th of July, it'll be 4 weeks only.
Okay, okay, then 17th of July, it will be listed.
Much obliged.
Lordship, Lordship, I had one humble, Lordship may remember on Tuesday, we had one intensive hearing on 2 matters, WPC 32 and 78 of 2024, with regards to that forest compensation. Lordship had passed an
Passed the order, I think it is not uploaded.
Lordship, it is now. Lordship, Lordship, the learned counsel who was coming from Delhi, Mr. Kashyap, I believe the date was agreed on 26th of June, seeing the urgency. However, Lordship, the order reads as after 3 weeks, because Mr. Kashyap is the counsel coming from outstation, and I think the date decided was 24th of June.
Okay, in item number 4.
Lordship, my colleague is in the court. Once the Lordship matters are over,
Just provide us the item number and the number. Okay, we'll check it. If it is possible, then we'll take it out. Otherwise, it was listed for after 3 weeks.
3 weeks. What was decided was on the 24th of June, but the order
24th of June.
June.
Okay. Okay, we'll see to it. Okay.
Highly obliged.
Item number 19.
May I, Lordship? Lordship, the service report in respect of private respondent number 5 to 13 are still awaited, Lordship.
If service report is still awaited.
Yes.
5 to 13.
5 to 13.
1, 3.
5 to 13, 1, 3.
And 1 to 4, you are already appearing. You are Mr.
Yes, sir.
You are Mr.
Yeah, though.
Hard so appearing on behalf of the petition, and also hard MS so the learned government advocate. You are appearing for respondent number 1 to 4. 1 to 4. However, it is seen that the service report for respondent number 5 to 13 is still awaited. Post of service be awaited till next date of listing. List the matter accordingly on. After let it be awaited till another 2 weeks. Thereafter, you'll see. After 2 weeks. Was there any interim? Was there any interim? Interim order was there? Any interim order?
Yes, Lordship.
Huh?
Yes, Lordship. Interim is due.
What to do? It should be continued or what?
No, it may not be continued.
Considering the branch is a primary respondent. It should be continued till this. Item number 20?
20.
Oh, 20.
Item for 21 regarding item 21 when this 20% for the CBA.
So, I think some of the basic are available.
No, you are talking about item number 22. 21, yes, 21, some had mentioned.
Yeah. And for appearing for respondent number.
Okay.
Second book with the subtext. So I think in this case, the readings are almost complete. Okay. So we made it on somewhere in the month of.
I don't know, you just consult with the other side. We have already asked that whether the consent of the other side has been taken because Mr. M. Kato, he was appearing as the DSGR.
For,
Yes. So it was not within our knowledge anyway. It was either, in that case, it was fixed in 26th of July. Do you have any problem?
my name will be.
To upon Lucille, dictation. 21, when item number 21. What's your good name?
MK Boro.
MK?
Boro.
MK Boro appearing on behalf of respondent number. Who is the respondent number 2 in fact? Respondent number 2 is the?
The principal commissioner, CGSP and CS. Principal commissioner. General Goods and Services.
So you are standing counsel for?
General Goods and Services.
Standing counsel. So and so. Okay, I said item number 2 to level as well. Your presence will be recorded. Yes, 2020, yes.
Yes, ma'am. My lord, this is a 2020 matter, my lord, and pleadings are completed, my lord. So this may be kindly
Pleadings are
disposed
already
of to
completed.
them. This is, my lord, regarding non-payment of compensation, my lord. The only contention, my lord, on the part of the state respondents, my lord, is that compensation in respect of the flood I am claiming for has been paid to one Satish Chandra Sakma, my lord, which is not true. And this Satish Chandra Sakma myself, he himself has, my lord, clarified through affidavit that he was paid compensation in respect of another plot, that is plot number 126. But this plot number in question, that is 111, has been sold to me by him long back, my lord. So my plea, my lord, is that the similarly situated persons, all the adjacent plots, my lord, has been paid, my lord, except me, my lord. And the only contention on the part of the estate is that verification was done and compensation has been paid to another person, my lord. This Satish Chandra Sakma, who is respondent number 3, my lord. And admittedly, last order, my lord, of this court was that to find out whether
Compensation was paid to one?
to one Satish Chandra Sakma.
He is not the actual person. I mean, he is also a land holder or?
My lord, he is a landowner, but his part has been paid, my lord. But there is another plot, my lord. He was paid for plot number 126, my lord. But the compensation I'm claiming for is in respect of plot number 111, which has not been paid to me.
No, his claim was for 120, plot number 126 or 111? 111.
126 only.
His claim was?
Yes, ma'am.
Claim was over 126?
Yes. And accordingly.
And your plot is? Your plot is?
111, ma'am. 111. And admittedly, my lord, compensation in respect of 111 has not been paid, ma'am. This respondent, Satish Chandra Sakma, is also a stakeholder, my lord. But his part has been paid, my lord, accordingly. He also was a landowner, but plot number 111 belongs to me, my lord. But
no, why name of Satish Chandra Sakma? You are naming Satish Chandra Sakma.
Yes, ma'am.
He got his compensation for plot number 126.
Yes.
So how he is related with you?
Way back in 2009, my lord, this plot number 111 was purchased by me from Satish Chandra Sakma, my lord. And through
So for
a
plot number 111 also, Mr. Chakma has already received any payment
no,
for 1111?
no, my no, my. But the government is claiming, my lord, that compensation has been paid to Satish Sakma for this plot also, which is not true, my lord. So basically, my lord, now that even Satish Chandra Sakma has clarified through affidavit that he has sold.
Where is the affidavit?
Initially, my lord, that this.
Where is the affidavit sworn by him,
Fine,
Mr.
yes.
Chakma? Have you annexed that petition, affidavit, wherein he is sworn that he is not the owner of 111?
Yes, my lord, he has filed affidavit. my-
Where? No, where is the
He's
affidavit?
repeating.
Oh, you are appealing for?
Yes.
You have clarified. Acha.
This plot number 111. That has been, this particular plot has been sold to the petitioner. Within the year 2009. That I have enclosed.
Okay.
Sale agreement.
This is the sale agreement.
Yes, so the sale agreement.
Sale agreement or deed of gift? Acha, sale agreement. Okay.
Page number 7. So as part of this sale agreement, I have already transferred the property in the name of the petitioner. But way back in the year 2009. And this is with regards to plot number 111. And with regards to plot number 126, I have admitted that I have received compensation with regards to
126.
Now, plot number, and even also I have tried another additional evidence also.
Additional affidavit.
For additional affidavit also, I have enclosed down assessment sheets. It has been when by the responding authority that I have put my signature in down assessment report see with regards to plot number 111. However, lordship, this particular signature has been forged. That I already I have verified in my additional affidavit. This particular plot number 111 has already transferred and bequeathed to the petitioner way back in the year 2011. This ground assessment report, so this of 2012. I have nothing to do with the ground assessment sheet of 2012. Because that particular land was already transferred to the petitioner in the year 2000.
2011.
Yes, 111.
No, in 2011 it was.
This ground assessment which I have enclosed, it has been given by the respondent authority. It was date of assessment was 9/10/2012. That is 3 years after I have transferred the property to the petitioner.
So I'm not denying that I have not received compensation with regards to problem 100. But 111, I have not received anything. But any effectively signature has also been bought.
So, my lord, there is no material evidence to show, my lord, that the compensation in respect of plot number 111 was either received by me or by Satish Chandra Sakma, my lord. Although the state government is claiming that the payment is made, my lord. None of us received any compensation, my lord. There is no record to show, my lord. Otherwise, in other similarly situated cases, my lord, we use the money receipt and all, my lord. There is no payment receipt as such, my lord, in respect of this church. But in a mysterious way, my lord, they are claiming that compensation has been paid, my lord. But none of us received. That is my.
Yes. You're for land management?
Madam,
Land
yeah, from appearance to respondent number one.
One, two, three, 4, and 5. Oh, no.
I'm
For two. For two.
For two, my lord. My lord, I'll just show two documents from the writ petitioner, my lord. This is the document of the petitioner, my lord. And then sale agreement, my lord, it is at page number 17, my lord.
Yes.
My lord can see, although it has been projected to be executed on 2009, in the year 2009, my lord. 10th November 2009, but there is no seal and signature of any executive magistrate and all, my lord. This document is not registered in fact, my lord. Now, my lord, another document, my lord, give it, my lord, at page number 33.
30?
This document seems to
Page
be
number 30?
33.
33.
Annexure 9.
Hmm.
This document seems to be genuine, my lord, because it has the seal of the executive magistrate and it has been, my lord, registered. And my lord can see the date, my lord. 2019. 10 July 2019.
No, it's a gift deed, otherwise.
Gift deed, my lord. Now, my lord, see the difference, my lord. Another is sale deed, my lord. That is purported to have been entered on 10th November 2009. But my lord may kindly see the document, my lord. There is no signature of the executive magistrate. In the absence of such signature from the magistrate, my lord, the genuineness of this document is questionable, my lord. And my lord is aware of the evidence act, my lord. For a piece of document to be eligible for this evidence, in the term, my lord, it has to be have the signature. It has to be a registered document. Since it is not a registered document, my lord can see there is no seal signature. So this right have been, my lord, created after the assessment, my lord, this document. Because the other document, my lord, is I have shown, my lord, at page number 33. There is a seal of executive magistrate, my lord. both on the top and at the bottom, my lord. So therefore, my lord, now with the private respondent, my lord, says by filing this affidavit saying that the land was transferred to the petitioner
It was between whom? Mrs. Satish Chandra Shakma and whom?
and the petitioner, my lord.
And the petitioner.
Yes, petitioner.
So once you are saying, taking stand that it was sold to the petitioner in 2009. And then again, you're saying that it was a gift in a form of gift deed, it was registered in the 2019.
Yes.
How?
I am allowed to verify. I care of them of my affidavit in opposition. Page number 5. Where I have enclosed this particular gift deed. I have categorically mentioned that I was informed of the situation and circumstances that was being faced by the petitioner with regards to land compensation. So that and then that has been informed to me. So in order to validate the previous land sale agreement, which was not executed, I was asked to sign this particular gift deed. So only to validate the sale of the land that I have mentioned. In fact, I have not hidden this document. I have not in the affidavit itself, where I have mentioned that in order to validate that, since this party there was controversy with regards to plot number 111. So to validate that I was
validate the said sale. You again executed one another gift deed. So how can?
The issue here is the interesting thing. Practice out here is proceed. Even if the land is sold, normally the parties used to make two documents. I mean, two instruments basically. One in the form of sale and another in the form of gift deed. Because suppose if the land is if a particular land has been issued with a land possession certificate, and land possession certificate land cannot be transferred by way of sale deed. So because of that, what normally the practice is, they will enter into sale deed just for the record that the particular land has been purchased, and they used to the party to make another instrument in the form of gift deed in order to transfer the ownership of the land. That has been done in this instance.
May I, Lordship? Lordship, this Satish Chandra. Lordship, may I kindly come to my last affidavit in opposition last page, Lordship. Lordship, this 11111 allotment plot it has been. Lordship.
Where we have come in para? Your affidavit in opposition.
My affidavit, okay. Annexure L, page 29.
You are for 3, not 2.
3, Lordship. Deputy Commissioner. Lordship, it makes clear, Lordship, here. Page 29. Lordship. Here, Lordship, the order from the Deputy Commissioner, 2nd April 2019, Lordship. Whereas the government of Arunachal Pradesh had notified acquisition of so and so acres land for green airfield at Polongi by so and so. That at 13/2/2013, it was not Lordship, notified, Lordship. Whereas district administrator has issued a public notice so and so dated 26/9/2012 for physical verification and identification of plot owners, Lordship. Lordship did not put it. Lordship got it, my page. Lordship. Lordship, here, Whereas during field survey on 9, 10, 12, Mr. Satish Chandra Chakma was present for survey of the plot number 111, but he never informed the DLRSO and DLRNSO or any other land management staff present about any such agreement of sale between him and Mr. Kipatai. Rather, he claimed plot number 111 to be his rehabilitation and resettlement land, as is evident from his signature on the ground assessment sheet, Lordship, dated 9/10/2012. And Lordship, the government, whereas the government of Arunachal Pradesh has submitted the said field survey report to the Honorable High Court in PIL number so and so in 2015. Also, same document has been furnished before NHRC, National Human Rights Commission, Lordship, in the case number so and so in 28/8/2013. In all these documents, Mr. Satish Chandra Chakma has been shown as the beneficiary of plot number 111. Lordship. In all these times, he was the beneficiary. It was his land. The name was never changed, Lordship, in the original document. Then where from Kipatai comes, Lordship, this petitioner, Lordship. And this plot of land, Lordship, has been, Lordship, against this land, Lordship, as per the direction from the NHRC, Lordship, they have been given within Arunachal government, and then there is from Chakma Rehabilitation Group also. They have their own president and secretaries. Their president and secretaries, after making consultation from their community, Lordship, they give us the plot number, documents, everything to the government. Accordingly, government give the land, another plot to another area, and they have taken that. And then in the beginning.
To another area, the Chakma was given another plot.
Yes, Lordship. And then not only him, all the people in that area, Lordship. Some were given, some plots were paid as compensation in monetary, Lordship, and some were given compensation from land against land, Lordship. So this 111 was land against land, Lordship. So their president secretary, they have tried to give him the plot, but he have refused to accept the plot, Lordship. From the beginning, he have put his signature, everything he agreed, but in the end, Lordship, when I took Lordship instruction from the government, Lordship, they have they asked from the president and secretary, the executive body, and they have given the document saying that he has denied to accept. Against this plot, there is no money loss, only land against land loss. So, Lordship, it's clear that the petitioner and the private respondent, they have nexus, Lordship. We have nothing to do with that problem, Lordship. We have paid the Lordship. For
So by
126, we have paid.
this thing that he also accepted to, I mean, receive the another part of them.
Another 128 money.
No hand measuring so and so per assess and initially the land part of it. Expressed his willingness and happiness to accept during the meeting of saying, however, later on he refused to accept.
Yes.
To take the possession of the land so and so.
Land measuring this much, Lordship, to so and so. Because his name is there, Lordship, in the roll. Not this petitioner's name. already land has been provided against 111 lots, plot number 111. If he's lots not interested in that land, we cannot do anything now, lots. That has been handed over long time back, lots, during 2013, lots.
So, my lord, I may be allowed to make a further clarification, my lord. My lord, so first on the, my lord, the legality and validity of this gift deed and sale deed, my lord. So, Stamp Act, my lord, came into force in the state of Arunachal Pradesh only in the year 2007. But that was line not applied, my lord. It was only, it remained only on paper. So registration and all that was not required prior to 2010, my lord. In any case, my lord, the lane was transferred by way of sale deed in the year 2009. And lane was under continuous and peaceful possession of the petitioner, my lord. So, in the last moment, when discrepancy arises, my lord, in the matter of compensation, when the validity of the paper was questioned, my lord, in order to validate the sale deed of the 2009, my lord, they reached an agreement by way of this gift deed, my lord. And in the gift deed itself, my lord, it is mentioned, my lord, that in the gift deed itself, my lord, that there is it has been clearly mentioned that the lane is under continuous possession of the petitioner since the year 2009, my lord. My lord, my lord, lordship may kindly ferry page 34, my lord, of the gift deed. This deed witnessed that in consideration of the close affinity and relationship of the donor had and still has for the donee, the latter being a family friend, the donor do hereby grant, convey, transfer, give, and assure unto the donee to the use of the donee freely and voluntarily the property mentioned and described in the schedule hereto, which is already under continuous possession of the donee since the year 2009. So, my lord, clarification has already also been made in this gift deed, my lord, that the lane is under continuous.
It's not disputed by them. That's why, as per him, this gift deed was there.
Yes,
It's
yes.
not disputed that it is given to you by respondent number 6. Respondent number 6 has not been disputed. But the question is that if he was, suppose he was not the possessor or owner of the land
Yes.
at that particular point of time in 2012, why didn't he did not raise any objection while his name was there in
Yeah.
the,
Yes,
against
my
the
lord.
plot number 111? Rather, land was given to him also. He refused to accept. So at that point of time, why didn't have any raise any objection? That is not under my position. It is already been sold, and that kind of land document could have been produced before the authority concerned.
Yes, my lord.
That in that time period, he remained silent.
To
But
that
now
aspect
he is
also.
saying, and he clarified that I have already sold the land.
Yes. So, my lord, on that aspect also, my lord, I'll convince this court that the respondent actually is misleading, my lord, with material evidence, my lord. The ground reality, my lord, is that when the petitioner, during the time of assessment, ground assessment, this petitioner originally belonged to some village in Kurunkume district, which is very far away from here, my lord. And at that time, there was no mobile network. So when he came down to Itanagar and came to know that compensation, ground assessment are being done, my lord, where he was not present, my lord. So he filed a complaint, my lord. When he learned that the owner of the plot number 111 has been wrongly reflected and mentioned as Satish Chandra Sakma, immediately when he came to know that, he immediately filed a complaint, my lord. That is at page 18, annexure 2 of my writ petition, my lord. This was filed way back in 12 December 2012, my lord, 2012. Addressed to the Land Revenue and Settlement Officer, Papumpare District, my lord. Subject regarding non-allotment on plot number of my land at Sakman number 2 of Kokila village, proposed green airfield, my lord. This is the first complaint, my lord. I have the honor to inform you that I have 2 plots under the proposed greenfield at Kokila, one near Kokila town, another at Sakma number 2. I have not got the plot number of my land. I also have no knowledge or information regarding depth of measurement of plot at Kokila for green airfield. Due to that, I was at Koloriang during the time of the plot measurement as my family is threat. Therefore, kindly verify and give my plot number and measurement details, please, my lord. So, after receipt of this complaint also, the authority did nothing, my lord. So, a subsequent complaint, my lord, was filed by the petitioner on 9/9/2014, my lord, which was addressed to the Deputy Commissioner, Papumpare District, my lord. May I read, my lord? Subject for rectification of name of owner recorded in the ground assessment sheet, Greenfield Airport, Holongi, dated 9/10/2012, in respect of the plot number 111, situated at village Sakman number 2, Kokila Circle, Balijan. Sir, as report above, most respectfully, I beg to state that at the time of survey and ground assessment undertaken by the concerned department in respect of those plots of land required for the proposed Greenfield Airport, Holongi, I was at Koloriang. Thus, in my absence, I could not make proper representation in respect of my plot of land situated, which would be affected, ma'am. That in the ground assessment sheet prepared by your office in respect of plot number 111, situated village Sakma number 2, Kokila, Circle, Balijan, in the name of Sri Satish Chandra Sakma, is wrongly recorded as the owner of the plot, whereas I am the real owner of the said plot of land, and the same is under my peaceful and open possession without any encumbrance whatsoever. Sri Satish Chandra Sakma, though also possesses the land there, but his plot is in the western side of my aforesaid plot of land. And therefore, it is humbly prayed that the name of the Satish Chandra Sakma, recorded as owner of the said plot number 111, may kindly be rectified, modified, and my name may be kindly be recorded as the owner of the said plot bearing number 111, my lord. This subsequent complaint was also received by the authority, but and as a result of this subsequent complaint, my lord, notice were issued, my lord, to both the parties, to Satish Chandra Sakma and me, my lord. That is at page 20, my lord, Annexure 4. And this is addressed to Sri Satish, dated 15 September 2014. To Sri Satish Chandra Sakma, address Kokila, notice, whereas claim and objection has been received against your plot number 111, which is affected under the proposed Greenfield Airport, Holongi, Itanagar from 1 Sri Kipatai, that is the petitioner mine of Itanagar, by this office in pursuance to the public notice dated 22nd August 2014. Therefore, you are hereby directed to present on 19 September in person or through pleader with relevant records or documents in support of your claim to dispose of the same on the disputed plot as per that fixed above positively. Take note that failure on your part, then matter will be decided in your presence ex parte, my lord. So, in compliance of this notice, my lord, both Satish Chandra Sakma and the petitioner appeared, my lord. But on that day, no hearing was done. So, both Satish Chandra Sakma and the petitioner, my lord, they repeatedly plead the authorities to fix another, my lord, another date for hearing, my lord. But in spite of repeated requests, my lord, all the requests has gone into the depth here actually of the authorities, my lord. And this notice, as on today, this notice has not been given effect to, my lord. So no hearing is done in spite of repeated requests, my lord. They are only claiming that during the ground assessment report, Satish Chandra Sakma was present. But in any case, even if it is presumed that he was present, the petitioner was not. So, by way of filing affidavit, Satish Chandra Sakma has also, my lord, clarified that he was present on the plot only in respect of, only for the payment of compensation in respect of plot number 126, my lord. So, if at all, my lord, compensation has been paid to the petitioner or to Satish Chandra Sakma, my lord, they should be able to produce the record, my lord. The record of such compensation I have annex 1, my lord, is at page 24 of my writ petition, annexure 6, my lord. This is one example paid to one Kipa Jemo. He received 32,07,000. So the authority should able to produce this kind of documents, my lord, if at all payment has been made, my lord. On our part, there is no question of producing because we have never received such amount, my lord.
That they cannot produce because the question is that they are not paying money against the land, they land against land. That is their plea, I think, in government side. They have not provided, they have not paid any compensation in terms of money, but they are providing land in exchange of plot number 111.
Yes,
That is their plea.
yes. My lord, in
So
any
money
case,
receipt will not be there.
in any case, my lord, the notice issued by the respondent themselves, this has not been given effect to, my lord. So none of the parties has been given any opportunity of being heard, my lord. The actual owner of plot number 111 is yet to be decided, my lord. That is the ground reality. So, my lord, in
Yes.
that case, my lord, the respondent authority may be, my lord, directed to give effect to this notice, my lord, and both the parties may be heard in person, my lord. Because this is the notice issued by them, my lord, on the repeated complaint filed by the petitioner, my lord.
Hmm. That has been already disposed, Lord Sir. There are, okay.
My lord, this honorable court, my lord. My lord has seen, my friend has shown the representation made by the petitioner to the deputy commissioner and the land revenue settlement officer. My lord, at page number 18.
It is
Yes, of the petition, my lord. This is one of the representation made to DLRSO, my lord, by the petitioner, my lord.
Yes.
My lord,
That has already been.
yes, already been shown, my lord. My lord, may I see the contents, my lord. They are claiming that both this petitioner and the private respondent, they are claiming that the sale deed was executed in the year 2009, my lord. But still, my lord, here is their representation, my lord. There is no whisper about this sale deed, my lord. Had it been really entered in between both the parties, my lord, on the basis of that sale deed only, I am claiming this land, the plot number 111. The petitioner ought to have said that, my lord, in this representation. And again, my lord, next page, my lord, page number 19, my lord. This is a representation made to deputy commissioner by the petitioner. That was on 9/9/2014. 5 years after the purported sale deed, my lord. Here also, my lord, there is no whisper about the sale deed, my lord.
I have a, my lord, objection.
No,
The
just
petition-
let him.
Now, my lord, all these, his representation, my lord, that was decided on 2nd April 2019, at page number 31, my lord. Deputy Commissioner has disposed of his representation. In the last line of this order, my lord, page number 31, down below, my lord. Therefore, the agreement of sale deeds so and so between Sri Tripathi and Sri Satish Chandra Sakma as being unregistered, agreement is invalid. It does not affect transfer of any immovable property, and therefore the representation by Sri Tripathi is liable to be rejected. Although, my lord, he has not said that no, there is actually a sale deed. But then, my lord, even it can be presumed that during the disposal of this passing of this order, they have even not placed that sale deed, my lord. That is why, my lord, from the very beginning, I am saying that there is a nexus in between the petitioner and the private respondent. had they really entered into this agreement, sale deed of 2009, my lord, there would have been some mention of that sale deed, my lord, in all the representation submitted by the petitioner, my lord. But there is, my lord has seen, there is no whisper about that, my lord. That is why, my lord, I have doubt, my lord. This sale deed is what this afterthought creation, my lord. There was no actually this
But
sale deed, my lord.
just I want to ask you. Now the question is that as per the government, for plot number 111,
My lord.
no compensation in terms of money was paid. That is admitted. And he is repeatedly saying that the government is failed to produce any that kind of money receipt and all. And that is admitted fact that money was not given. It was not in terms of money. But was she saying that another plot of land was offered to Mr. Chakma? Initially he agreed to receive that amount and subsequently he refused to accept that plot of land. Can it be there any thing that there may be if suppose he claim he submits or he clarifies that he is not the owner of plot number 111, can there be any representation from the petitioner side that may be considered in terms of land? Can it be? If it is that any possible way?
Lordship, Lordship, may kindly see my page 8. In the para 11, we have cleared it, Lordship. Basically, while para 11, Lordship. For that, there was already an order passed by this honorable court, Lordship. Here, we
Para 11 of your
paragraph 11, Lordship.
of your affidavit.
Affidavit.
So,
Paragraph
yeah,
11, page 8.
Lordship.
Page 8.
You are 3, isn't it?
Yes, sir.
You are 3 and 4.
Yes, 3 and 4.
So para
Page
11, just.
Para 11.
Para 11 and 11. Where is the para 11 in fact? 5, 6, para 6,
Page number 8.
page number 8.
Affidavit by respondent number 3 and 4. Lordship.
3 and 4, para 11. Just a second, you have just check. Okay.
Lordship, see this, there is
Second,
nothing to. Para
flag
11.
is not there, Nikki.
Lordship.
Why I'm missing it? Oh, flag was there too.
Yes.
Okay.
Para 11. Lordship, here the
Yes.
respondent begs to state that in compliance of the judgment order passed by this honorable court by dated 8/3/2019 for field verification of plot number 111, it was also directed. Accordingly, field verification was conducted on ground at plot number 111, and it was found that the land which is claimed by Sri Hipa falls under the category of rehabilitation and resettlement. That is land against land. Lordship, this is land, which was already issued in the name of Satish Chandra Chakma, as per direction issued by NHRC, Lordship, Delhi, by letter number so and so, Lordship. So, dated 28/8/2013, Lordship, this makes it clear. We have done ground verification also. After the honorable court has, this honorable court has directed by 8/3/2019 lordship. Field verification was done. After verification only, it was found that this 111 falls within lordship rehabilitation resettlement this one land lordship. As per the direction given by the NHRC lordship. So that's why their land portion of land was given to them lordship from their own lordship executive bodies. They were supposed to identify each one and hand it over to them. It has been done by the executive lordship. I have given a document and we have refused lordship. Now lordship, the authority lordship, we have nothing to do lordship. Actually.
Oh,
Obliged.
my lord,
Yes, you have already
Since-
clarified the matter.
my lord, no,
You
no,
have
my
already
lord,
clarified.
my lord, since they are repeatedly saying that there's nexus between the petitioner and the Satish Chandra Sakma, my lord. I'm compelled, equally have the right to, my lord, reiterate, my lord. The ground reality is that this is not the only case, my lord. The authority in ground reality, my lord, they used to siphon of money in the name of many mysterious name, my lord. This same is the case here, my lord. They are claiming that they have faith to Satish Chandra Sakma. And if at all they have faith, my lord, or if they have actions land for land against land, my lord, they should be able to show that the land, show the plot of land that is given to Satish Chandra Sakma against the plot number 111, my lord. And my lord, as regards, my lord, ground verification, my lord, anything should be done in presence of the complainant and Satish Chandra Sakma, my lord. Notice was issued, no hearing was done, and they're claiming that ground assessment was done, but neither Satish Chandra Sakma was present, nor the petitioner was present, my lord. How can that be, my lord? And just for the sake of disposal, they have shown this disposal order, my lord. That too without hearing the petitioner, my lord. How can that be, my lord? In their notice, the petitioner was directed to come with documentary evidence, my lord. Accordingly, he even submitted documentary evidence, everything, my lord. But that was not verified in presence of all the stakeholders, my lord. How can that be, my lord? So, to find out the, my lord, through the respondent authority, my lord, may be directed to make a ground verification report in presence of the parties, my lord. And hearing should be conducted, my lord, in presence of the parties, my lord. In any case, there is a complaint which has not been addressed to, my lord. And in presence of just to conceal their own misdeed, my lord, they have shown that representation of the petitioner has been disposed of under mysterious way, my lord. This cannot be allowed to, my lord. So, my lord, the petitioner cannot be left remediless, my lord. He has not been granted what he has prayed for, my lord. His grievance is that the actual owner of plot number 111 should be, my lord, ascertained. And assessment should be done in presence of the parties, my lord, which has not been done. And if at all land against land has been, my lord, compensated to Satish Chandra Sakma, then they should be able to show that land, my lord, allotted to Satish Chandra Sakma against this 111. They are just, instead of, my lord,
They are saying in their letter that land measuring 14,183 square meter were offered to Chakma.
If that particular land has been offered in place of 111 as a compensation or as a resettlement. So that would be refused, obviously, lordship, because plot number 111 has already been sold to the petitioner. After selling the land to the petitioner, how can I accept that land?
crores of money are being siphoned up by them. But out of ignorance, people are not coming to this court, even, my lord. That is the ground reality. And in this case also, my lord, under mysterious circumstances, they have misused, my lord. So, my lord, my prayer, my lord, would be that at least adequate opportunity of being heard should be afforded, my lord, to the petitioner in presence of Satish Chandra Sakma, whether it is hearing in the office or a ground assessment, my lord. And if at all they are claiming that lane against lane has been granted to Satish Chandra Sakma, then they should be able to show which area or plot of land has been granted to Satish Chandra Sakma in place of again 100 plot number 111. Man. That is my submission.
They have placed this document. You can,
Lord Sir, I have given.
from this document, it is seen that one plot of land which was identified by the government was in fact handed over to this respondent number C, but he refused.
Because in the record, his name is there, Lord Sir.
This is
Now
a
he is explaining that he refused to accept that land earlier, though initially he accepted and subsequently he refused to accept because it was not his plot of land. That is his submission at present, but there is no such explanation. I don't know whether there's such kind of explanation was before the state authority at the time while the land was offering to him in place of plot number 111. That is not
Verifying the place now is plot is impossible, Lord Sir. It has been made airfield now, airport now, Lord Sir. It's greenfield. It's under the Lord Sir.
This is
airport, Lord Sir.
This is of 2019, my lord. My complaint is pending since 2012, my.
As per him, that has already been disposed of.
No, my
Your complaint or representation two representation were already been disposed of.
My lord, in disposal order, there is no mention of plot number 111, and I was not present, my lord. Anything, my lord, should be done in presence of the parties, my lord.
See.
So hearing may be conducted, my lord, in presence of the parties, my lord.
Here on item number 20. Or 20? 22. It was written in 1906. It was 1963. Right? 20. 20 is 1960. Okay, we confirm it with this one. Right? Confirm which submit. We are on 22. Let's see. So one more item is at 2. One more item is at fixed 2. Okay, we pass. It will be
Sorry, my lord,
Obliged.
against this disposal order, I have come, my lord, because that may be recorded.
I am for
Obliged.
1, 3, 4, and 5.
In which item number? 26.
Respondent type.
In this item, my lord.
In this
Oh,
item.
yes, oh, yes, yes, it will be recorded.
Yes, 1, 3, 4, and 5.
Low data. Land management to asset, state asset, and he is respondent number 6.
Much applies.
Okay.
Lordship, here petitioners having a limited grievances and prayers. Her name was wrongly, inadvertently, her date of birth was written some different date.
No, you're for the respondent side.
Yes,
Your
CBS.
name has not been reflected, no? Name
No,
of,
name
you're for
not-
CB?
CBS.
Date of birth.
CBS.
Yes, but name is not shown in the causing, but earlier date was fixed on the earlier occasion, that's why.
You were there.
Yes. Regarding correction of date.
Because date of birth.
One thing Lordship can do, giving direction, Lordship, they may submit the representation before the CBSE, regional officer, CBSE, with original document through the principal of the school. So they have not made the principal as a party in this petition, but through principal, they should submit the representation to the CBSE, forwarded through principal will forward the application. And then CBSE will consider Lordship, because at the time of admission, Lordship form, everything his date of correct birth was correctly recorded.
Actually, earlier, the petitioner have approached the principal of the school and by submitting representation and personally meeting the principal of Government High Secondary School, SEPA. From their principal have forwarded that her representation and grievances to the CBSE board. After forwarding that, CBSE board have stated that at this stage they are unable to correct the date of birth of the petitioner. This
So
was the
now by
case.
this, what are you seeking for? For correction of the date
We
of birth?
need only the correction,
Is
because
there
due to
any-
which
Higher
my
secondary, they have stated in the petition, the higher secondary mark sheet, their date of birth was correctly recorded. But
In higher secondary?
Higher secondary.
it was supposed to be my date of birth was 17/6/2005.
Ah.
But they have mistakenly it was entered as 29/6/2000. 5 years.
29/6?
2000.
2000?
2000. 5 years.
In certificate of matriculation or what?
In a matriculation certificate. So due to which I am facing problems. So I have approached my school authorities, the principal also, and they have forwarded that.
No, as
my-
per you, they can approach. Mrs. Bora, he can approach.
He can approach.
But
Earlier
as
also
per
they
her,
have, they have
the date
submitted
of birth is correct in your high secondary certificate, is it?
high secondary.
Higher secondary certificate.
Yes,
And
they
they
have
have,
not annexed, they have not annexed the high
I have
secondary.
annexed it.
Annexed. Which page?
Page number 17.
Oh, the high secondary, no?
You
It
passed
was,
your, you passed your HSLC in which year? You have passed your HSLC in which year? You know,
Metric.
it's available.
Metric. Not annexed.
The date is not so clear.
See all these things at the time of result or at the time of the
12
issuing your registration card and all, admit card and all, why you didn't need any objections regarding your date of birth
Yes,
and all?
passport in which year? Metric?
Passport.
Passport.
Passed on from standard 2010. 12.
This one is 2012 certificate, not high secondary.
Class 10, she passed class 10 on 2012, Your Lordship.
Yes.
And in that certificate, the date of birth is written as 29/6/1994 instead of 29/6/2000. It should be that.
Then can it be any direction at this stage that he may produce all these documents? On
Okay.
what basis you want to now, you're claiming that your date of birth is of 2005,
Actually,
not 2000, huh? Only on the basis of the affidavit?
only on the certificate or pass certificate, it should be been at 29/6/2000, Your Lordship, but mistakenly it has been entered as 29/6/1994. So after that, we, for that correction, she even made the principal and requested the principal, and even representation was submitted before the principal. Then that principal have again forwarded
No,
the-
obviously, after lapse of 1 year, most probably they are, how they can correct the date of birth and all, that is
So,
not the
Your Lordship,
procedure, I think.
my prayer is that the petitioner will
be some
submit a
time
fresh
period.
representation before the CBSE authorities to consider to consider to
So now what
correct.
will be the, as per you, what will be the process now? How it, because the court cannot pass the order that you are of your date of birth is
cannot
2000.
pass,
We cannot
corrected.
pass.
Court
It
cannot
has to
pass.
be assessed, it has to be seen by the CBSE authority or the Board of Education.
Wait,
We are not, how can you, how the court can pass that? Yes, your date of birth is not 2005, but 2000, how can you say?
when the CBSE authorities have sent a reply to the principal of government high secondary SEPA that now they will are unable to correct it. It can only, remedies can be seen only through court. So we have filed this petition.
As per rule, Lordship, they had annexed.
As per rule under
Amended
CBSE.
rule. Last page, page number 28.
Page number?
28.
The
69.3 B. That's why they have correction as per court's orders. With them.
Page number 28, Your Lordship. Under that rule, correction as per court orders. Application regarding correction in date of birth of candidates will be considered provided by entertained by board only within 1 year of the date of declaration of reserve. No correction whatsoever shall be made on application submitted after the said period of 1 year. Correction have been fully admitted by court of law. In case of correction in date of birth in documents after the
So
court.
now what kind of direction you need? Because it
Here
is the, it
only-
is the amended, as per the amended provision itself.
Yes, Lord.
After 1 year, most probably they cannot entertain your petition.
Yes.
For correction. So now what is your stand? What is your plea?
Our
Simply you cannot say that court can direct the, because there is an, even after the amendment rule also, as
yes.
per the amendment rule also,
It should
within
be
1 year
under
you
1
have,
year.
because I am the victim. That's why I'm saying, I am also one of the victim, personally. My birth certificate, I mean the school certificate, 2 years gap is there. So I am the victim also.
Here,
So that's what I'm also interested. How can
here
it be?
I can
possible?
say the petitioner
Because my
also was
father also went to
negligence.
the Board of
She should
Secondary
have-
Education, that was not.
They should immediately approach.
She should have approached earlier, but she also
Yes.
They have not approached.
have
Now,
commit
when
negligence.
when she passed her
12.
HSLC in the year 2012,
2000.
then you
She
see
should be
matric,
vigilant.
12, high secondary, I think it is 14.
high secondary 14, matric is 12, but the
Matric is 12.
confusion, date of confusion is in the matric certificate.
Metric certificate.
Metric
It
certificate.
Not
should
in
be
the high
in
secondary
2000. She was
They have
born
mentioned about the high
2000
secondary, but.
in the year 2000, but
Now in high secondary certificates, is there any correction needed in high secondary certificate also?
not in high secondary, only in class 10.
No, high secondary is all right. Okay.
Yeah.
The soda certificate, high secondary. They have not annexed that certificate, high
Class
secondary.
12. But as per that petitioner, that for high secondary there is no any problem. Only in class 10 it was entered as and
But higher secondary.
date
who
of
has-
birth should be in the year 2000, but it was entered as 1994. That is only there.
That the
But,
date of birth is entered in the high secondary certificate also as per the matriculation certificate.
Matriculation in class 10 pass certificate.
So
Which-
say what to do now?
So
High
our
secondary,
praise that
the certificate, whether the date was correctly
Yes.
recorded or not, high secondary certificate.
Yeah, but annexed, the high secondary certificate is not annexed.
I'll inquire and if not, then your lordship, my only prayer will be that portion where date of birth has been wrongly reflected or entered, that may be corrected by the CBSE. She will
That is not the procedure. Then in that case, so everything even me, I will also approach the High Court or Supreme Court to correct my date of that is not the procedure.
Time. Limitation of time is there, 12 CS password, now 24 or 19, I think they have.
So any
In-
further
in,
submission
of,
you
your
want to make,
lordship-
even in that case, I'll hear it at 2. If you want to make any clarification, any further submission, make a consultation, or I can fix this week, next week, any date. Or if you want to make it more clarification, if you want to make it more
in,
clarification, then I will hear it too. It's already one.
For only 1 year also, it wouldn't different. 6 years different.
Obviously.
That is
Mine is 2 years,
2000
for
and
you it is 4
1994.
years.
6 years is very long years. If 2-3 months or one.
Certificate, Lordship.
So I pray
as
the
per the
CBSE authority, if there
It
is
is
any
correctly issued by the
alternative
CBSE.
source, then she will submit a fresh representation with all the documents, class 10, 12, pass
Yes,
certificate.
what we
Yeah,
say.
that
If
can
they,
be
if
done.
they consider or say on the merit or
You want
on
to file a fresh
humanitarian,
representation with all the documents.
all the
Original
documents.
Through the principal, Lordship.
To the
Through,
principal.
through the principal, will submit before the principal
Forward
and
the application of the applicant to the regional officer.
But my
CBSE.
question is that as per the or as per the, even after amendment also, this is only for 1 year.
No,
Will it
amendment
be a
after
proper
5 years maybe?
order?
Here it is been said in the amendment rule that after 1 year, if it is not being corrected, then the petitioner aggrieved can approach the court.
Where is it?
That correction of as per court, last, last,
Last
28.
Last.
page number 28
number
and 29.
28.
Correction as per court orders. Application regarding correction in date of birth of candidate will be
Acha,
considered
court of law, okay.
provided correction have entertained
Earlier
by
it
the
was
court
1 year, later
only
it was
by
extended to 5 years.
But in his case, she did her in 2012.
12,
So already
17,
no, this application was filed on 2023 only.
23, no, 19, I think.
23.
23 last year.
Then after 10,
Last
10, 11 years, then
10 years.
is it
In
wrong?
between, she
Where
approached
is it
the
in between? Where is it
prince-
in the word in between?
It's
she
principal.
earlier approaching this honorable court. She
Not there.
she even
After 1 year, correction have been
She cannot
admitted by
approach
the
this.
court of law in case of correction.
no, earlier she even went to the principal of the school, requested the principal, even submitted.
Where
application.
is it in? It is 5 years. It has to be 5 years.
Yes,
Where
5
is the
years.
clarification? Where?
Uh,
In point number?
mm,
Within 1 year was earlier there and then
under 5 years, page 27.
27.
That is regarding correction of name. Sorry, Lord. Change of date of birth.
Correction of name only.
Correction of name. Here also-
Correction in
Is there
name.
any point where from we can get that after 1 year, what is the period, within which period the court of, the one can approach the court of law? I have not seen anything here.
Did you correction as per?
Your lordship, I'll take time once I'll make some research if there is any possible way to meet up the
So
grievances.
when can it be fixed? Because she has come
Yes,
from
I have
Guwahati,
to
no?
come from
It's her
Guwahati.
difficulty.
To her convenient date,
As per her convenience.
convenient date. I have no idea.
Yes, by the any convenient date.
Here, your lordship, so many years will have effect on the.
But
petition.
let them produce the higher secondary certificate. If it is issued
Yes,
by the
we'll
CBSE, then there will be no difficulty to correct the actually.
Hmm.
The date of birth.
And if proper age is there mentioned in the higher secondary certificate, that will serve its purpose.
Yes, yes.
Or on that basis of the higher secondary certificate, it may be
Yeah,
corrected or it may.
corrected. But
So
they are not
now
trying
you
for
produce the
correction.
higher secondary certificate and all in that case.
Yeah, I'll place the class 12 certificate also.
Heard Mr. A. Bhattacharya, the learned counsel for the petition, also heard Mr. M.S. Arbora, the learned standing counsel CBSE.
Response number 1 and 2.
This person appeared for response number 1 and 2. It is submitted by Mr. Bhattacharya that he will, M.S. Bora, the learned standing counsel, submitted that the petitioner may be directed to furnish the pass certificate of higher secondary, which may help in assessing the age of the present petition. Accordingly, the petitioner is ever directed to produce all other relevant documents, including the first certificate of the higher secondary examination on next date of listing, on or before the next date of listing, and matter may be listed accordingly. Yes,
when
as per your convenience, we are going to.
Actually,
Yes, for your condition.
July, I have difficulties. June 17,
June
Monday.
17, Monday,
or Friday will be better, 21st June.
21st of June.
Your lordship will be there. Your lordship
Pardon?
will be there.
Me, I'll not be here. I'll not be.
Then we fix it. It will be
Any that, madam, as your convenience, I will say, I'm staying here only.
Yes. Cannot say this thing.
Next week.
If it
Next
can be fixed, I'm here till next week.
12,
Next.
13.
Next week I'm here. If it is your,
14.
but don't make it on 14th.
Yes.
I have something
13th.
we have to rush to Guwahati, in fact.
13,
So yes, 13, 12, I'm ready.
13.
13.
13 can be, yes. 13, 12, I'm ready. But don't make it on 14th.
Wednesday.
And meantime, I'll
Yes, yes, correct. correct.
produce the
Yes.
class 12.
Because this sounds CBSE also has no such kind of objections,
Yes.
because it is a matter of 4, 5 years,
Yes,
not 1, 2
yeah.
years.
This is
So
not
we can also understand. that
petitioner,
will
so
affect
there
her
is no
and
import of
get-
the
Yes,
petitioner,
definitely.
but petitioner have
So 13 or 12?
13.
13th. Okay, list on 13th.
obliged.
You annex all the document, we'll try to.
One second.
And if there is any such thing that within 5 years or something is there, because in amended
Yes.
portion, I have not, I mean, I have not seen any such kind of these things. Point there in the amendment, even in the amendment rule also. So if you can produce any such
I'll
thing
try
that
my
within
best,
5
your
years, that
best,
can
your,
be.
your
That's
worship.
great. Because there has to be some limit. It is cannot be that after 20 years you come and after
Yes,
15
yes.
years.
Here petitioner
30 is good.
have committed negligence. She should have come earlier.
Okay.
She have not noticed seriously.
As per the such the guideline or notification, it has to be there only. Mention also is to be there.
Yes,
In before the before Justice Goswami.
as per the notification of
Okay,
30th May.
Or why you want to withdraw this one? Let the raise the ask to fix the matter before the Justice Goswami. You you may make a submission from here at the seat, and he may hear from the principal seat. It's okay, because we are not taking that kind of bill matters through VC only. That is.
I understand.
Oh. Add to what?
Please, Lordship.
Yes.
My lord, if the file of 93 has come.
Yes.
Your lordship may kindly see the array of the parties
In 93?
in 93.
What is this? This one? It will be there. It
Will be a-
Acha, anyway,
It will
93,
it will be at page 5. Array of the parties in 93. Page 5. Now, Messrs. Roshina Udyog respond added at 3, serial 3, and kindly see page 6. This is by pro forma, not a main party, because no relief is sought against the pro forma. Now, your lordship will kindly see the other writ petition, that is 115, that is also on your lordship's board.
yes.
In 115, your lordship may kindly come to page 80,
18,
only 80, 80.
80. Yes.
Now, 80 is the corrigendum which I am challenging in this repetition now. In 115, this corrigendum is already under challenge. The other repetition that I said. And kindly see your lordship's order on 3rd of June. First, your lordship will find the 29th April order. On the top of the file, 29th April order, the interim order is there. And last order is passed by your lordship on 3rd of June. That is this Monday, by continuing this interim order. And before that, your lordship will kindly see the order dated 30th of May, where this honorable court had noticed that the IA has been filed in this case by the respondents seeking vacation of the interim order. And despite that, my lord, the interim order was continued, which your lordship had eventually continued on 3rd of June. So today, when I am asking for a writ petition where I challenge the corrigendum, how can somebody raise an objection who is not even a party to this case? And this is exactly on the identical facts. Therefore, first of all, this corrigendum, which has been issued by the government, my lord, that does not confer any of the private parties any rights. So therefore, my challenge to the corrigendum does not in any way affect any of the rights of the private parties. And in fact, my lord, there is, if your lordship will kindly see my writ petition, I have only sought that this corrigendum should be set aside. Now, setting aside of this corrigendum, how it can be understood to have conferred any right in favor of the private free when the tender itself is at the initial stage of consideration. The lordship will kindly see.
115 also, they were identified profound dependent or not?
In 115, they were main respondent. Still thereafter, my lord, there is stay order and it is continuing. So therefore, today the submission which my learned friend had made in the morning, that they have got some interest, some right, etc., etc. What prejudice will be caused to them if the notice is issued on the writ petition? And a similar order which is operating in other two writ petitions is also observed in this case. What right of theirs will be affected, my lord? That is, I am unable to understand. Your lordship will kindly see my prayer at page 21. It starts from 20.
Yes.
First prayer, certiorari shall not be issued to set aside and coerce the impugned corrigendum dated so and so. Now, corrigendum is issued by the government, not by the private parties. Mandamus shall not be issued directing the respondents to forthwith cancel, recall, rescind, and or otherwise forbear from giving effect to the impugned corrigendum dated so and so. This is also the corrigendum, not even the NIT, because the NIT is under challenge in the other writ petitions, 93 and 115. And thereafter in page 21, the usual prayers, that interim prayer and all. So therefore, my humble and respectful submission is this, that first of all, since they are not party to the proceeding, they do not have any right to open their mouth in the present case. Secondly, I can understand, my lord, if some of their rights are going to be affected, it has to be their rights. It is not a public interest litigation that anybody and everybody can come and join. If any of their rights are going to be affected, my lord, then only possibly they can come and say that we are necessary parties and therefore in our absence, the petition should not be heard or noticed. So the submission that has been made by learned friend in the morning, that it is a case of non-joinder of necessary, that is absolutely, my lord, beyond any recognition of law. So my humble and respectful submission will be, your lordship will kindly issue notice on the matter. And since in other cases also there are interim orders in respect of the origin, also in respect of the NIT, your lordship, and I am not asking for an interim order to stay the process, because the first interim order which this honorable court has passed, that is also not to stay. The honorable court has observed that they should process the tender, but it should not be finalized without leave of the court. Your lordship will kindly have a relook at the order at page 53. The operating part will be at page 55. In the interim, it is directed that the respondent shall receive the bids in pursuance to the NIT dated so and so, and shall process the same on its own merits. There is no restriction that the government should not process or should keep the tender under stay. However, the award of work shall not be effected without leave of the court. Now, till date, government has not filed any application in other two writ petitions, saying that this interim order is prejudicial to the government. Where from and how a private party who is in no way at any better footing than the government can come and say that we are required to be heard. That's my submission, Lord.
May it please your
I'll
lordship,
hear
my
the, yes. Yes.
My lord, I am appearing. I have been told by my junior friend, Mr. Binter, about the case which is being moved before this honorable court in the morning. I have watched the video, my lord. Lot of things has been said by Mr. Dotto. First, I am very sorry and in a very sad state of affair that knowing fully that I have appeared in 93 of 2024 there, and my learned friend I have seen also in the morning. He is all the time saying performer, performer, performer. About 10 times he has said I am a performer respondent. My lord knows very well, if I have filed an application for vacating modification order, automatically I become the main defendants. I have an interest in this particular case. I am a bidder who has participated. My learned friends were agreed by the terms and conditions of the NIT. I am not agreed by the terms and conditions. Your lordship knows there are several judgments of the Supreme Court, how it has been dealt. Maybe the government has not filed an application modification variation of the order, but I have filed an application modification variation of the order. Knowing fully the matter has been fixed on 10th, and this was brought notice to the court earlier litigation 93, where my learned friend's client has filed a writ petition. And my lord will kindly see this writ petition was moved on 4/3/2024. Corrigendum first or the first time when it was moved. And there was some interim order which was passed by this honorable court. Now there is a corrigendum which was issued on 10/3/2024. When we appeared before this court, my lord, they made performer respondent. My lord will kindly see the order of this court on 23/2024. Kindly see the order of this court on 23/2024. Kindly see the second order passed by in 93. In 93.
In 93.
93 of 2024. Kindly see the second order. See how it was modified, the order. Kindly see the order of 23/2024, my lord. See 23/2024 order. My lord, third paragraph. Mr. Das, learned senior counsel, assisted by student learned counsel, has appeared on behalf of respondent 3 and submit. Since his client is interested in the outcome writ petition, hence the respondent 3 be heard in the matter. Similar is the prayer of so and so, my learned friend who is appearing. It appears that by order dated 4/3/2024, notice was issued only to respondent 1 and 2. And as a result, no copy of writ petition was served upon the respondent 3 and 4. In view of the above, issue notice to respondent 3 that where I am representing, and 4, this which my learned friend Mr. Talukdar is appearing. Since both the respondents are already represented, no formal notice is required to be sent. Now list the matter on 8/4. In the meantime, parties to interim order pass earlier to continue till the next day. So now my lord will now kindly see. Now my lord will kindly see. I have filed an application for modification variation of the order before this court. That's a IA which has been filed for modification variation of the order. IA 84 of 2024. 84 of 2024 has been filed in connection with 93 of 2024. Now in that case, my lord, my learned friend has filed an objection. We filed an affidavit bringing into notice about the corrigendum which was issued. Corrigendum was issued. My learned friend is aware of it, and the corrigendum was issued long back in month of March, 10th of March 2024. And we filed this application before this on bringing notice. And in another case similar, they also challenged. Corrigendum was also brought notice to the court. A writ petition was amended. Today, my learned friend's client has filed a writ petition without making us a party, knowing fully that we have contested in the other case. Am I audible, my lord?
You are audible. Your video is, video part is disturbing. Otherwise, you are audible.
It's okay, my lord. What I am
Now
saying,
it's,
my lord, what I am saying, that if you are aware that I have appeared in that case, which contains also the corrigendum, it was a duty of my learned friend's client to add me as a party. Why he has not added as a party, my lord? Normally, when this type of proceeding, if it is contested between the parties, if I want to file something which is related and where parties are there, normally we make parties, my lord, in the court. It is not that you are not making a party and you want to get some order, whatever the order you want, and on 10th you appear before the court and you'll say, see, there is an order of this court. This is nothing but to delay this matter. With great respect, I'm telling your lordship, the matter has been fixed on 10th. So my humble prayer before this honorable court, we are filing an application for impleading immediately so that the matter doesn't get delayed. My learned friend is saying government is not interested. Now today, as a result, we were supplying, my learned friend client was supplying. Today it has been stopped. And what is the supply of? This supply, my lord will kindly look into it. Supply for procurement of essential food items for children's, pregnant women, vulnerable, so these, my lord, these are important items. We are aggrieved. My learned friend is saying that how they are aggrieved. Why we are participating in the NIT. You may be aggrieved by the terms and condition. So my humble prayer before your lordship is that matter has been fixed on 10. There is already an interim order which is operating in favor of my learned friend's client.
They are also a party to 115.
And they are also a party to 115. So that corrigendum that has been brought by an amendment in that 115 in the writ petition, some protection is there. What is so hurry in this particular case? My lord and my learned friend is praying for interim order, similar prayer. So my objection before this honorable court, my lord, is that no interim order should be passed. Let it be tagged on 10th. We are filing an application for impleadment. We are interested in this case. And when, my lord, knows when a performer respondent is made a party and he contests the case, then he becomes the main respondent, and your lordship knows in a suit also he becomes the main defendant. My learned friend can't say what right we have got in this case. He has challenged the corrigendum that has been issued by the government. I will show before this court that terms and conditions are open for judicial review. How he is aggrieved. We'll show it. Maybe government has filed an affidavit in this case. Government has filed an affidavit in this case. So my humble submission before your lordship is that no interim order should be passed. Heaven will not for waiting for 1 day. So it is the matter has been listed on 10. And already there is a protection in those cases. How, my lord, this particular, how he will be affected? And he's saying that how we get prejudice. We get prejudice because of delay of this matter. This is what my submission, respectful submission is there. So my respectful submission, let this matter be taken up on 10. Already there is a protection in those cases. Anyhow, it will not affect my learned friend's client. That's my humble submission before your lordship.
My lord, I am appearing for respondent number 4 in WPC 93. I am also a party in the other WPC, that is 115. There I am respondent 7, and in WPC 93 I am respondent number 4. I have also filed my affidavit in opposition in both the matters. My submission is there is no pressing urgency today. The matters are anyway fixed on the 10th. Both the matters have been fixed. It's against the same tender. There is already a protection order operating. They're already protected. So let this matter be also tagged on the 10th and let all the matters be heard on 10th. As my learned senior said, this pertains to essential commodities for a vulnerable section of society. So we are aggrieved by the fact that the entire tender process from March has been delayed till June. We want an end to this. We want a quietus to this. So therefore, we are also interested. Even I'll be making an application for intervention or impleadment in this petition. We'll move that application on Monday. Let everything be taken up on Monday. It's just a matter of 2 days. That is my respectful submission.
One more submission, my lord. One more submission, if your lordship allows me, one more submission. 8th of April, but this is very important, 2024, but we file an affidavit before this honorable court, 8th of April 2024. We affidavit in opposition where we brought the corrigendum. And my learned friend is a petitioner. What made my learned friend to wait for so much time? What made him to wait? Why he did not, number one, why he did not file an application for amendment of writ petition? Why he has not moved the writ petition? Today, why he is moving the writ petition? And April, May, June, 3 months he have waited. Nothing is only for the purpose of delaying this matter and not making us a party, knowing fully that we are a party to other proceedings. Normally, my lord, as I am a senior counsel, I will never do it, my lord. I'm sorry to say, my lord. That's my humble submission before your lordship.
My lord, he has said the last submission, I am replying first. He has said that as a senior counsel, he has not done this previously. So my humble submission before your lordship will kindly ask him as a senior counsel, under what law he is entitled to make his stand in respect of this writ petition. This corrigendum, where the corrigendum is challenged, I am not on 93, not on 115. Where your lordship will please ask him as a senior counsel, under what law he is authorized to even open his mouth in this particular case, where no prayer is made against him. Under what law he is entitled, he will first explain. Secondly, he has this second submission he has made, that there are already interim orders passed in the other cases, and therefore no rights of my client will be affected. Just in the same vein, my lord, if the same order is repeated here, no rights of his client will also be affected. The reason being that even despite being pro forma party or the main party in the other two cases, the same interim orders are also operating against him. So repeating the same interim order, even in my case, will not prejudice him even for a single day. He is saying that this may be tagged and kept on 10th year. That is up to your lordship, my lord. I have got nothing to say on this. My only submission is that if there are interim orders against you in respect of similar matters, then what heaven will fall on you if the order is repeated in this particular case. And I have just shown to your lordship that on 3rd of this month, your lordship has extended the interim order in his presence. He was present in the court, and despite that, my lord, the interim order has been extended to be operative till 10th. So therefore, my case, if I am on a similar footing, if I have been able to show your lordship that I am on a similar footing to the other case, because the other case is also filed by the same petitioner, then what is the big difficulty? What is the prejudice that would be caused to them? The answer is very clear, my lord, that I will show, because on 10th also I will be probably, my lord, I am not sure whether I will be able to come or not. But if I come, I will show on 10th, my lord, why they are coming even despite being a pro forma party, why they are coming to contest this case. That I will show on 10th, because the things will come out. I will demonstrate even just from the writ petition, my lord, I will demonstrate it. So therefore, my lord, these two particular parties whom my learned friend Mr. Das and Mr. Talukdar are representing, today they are not to be heard. If they have got something to say, let them make their implement application or whatever. Because if they make an application for implement, I have got my right to object to it. I cannot simply merely agree that they will be added as a party. So unless and until they are implemented as a party, Lord, they have got no right to say. They have got no right to say, and specifically I have shown to your lordship that in the corrigendum which I have challenged here, it is an order passed by the government where, and one thing, he is saying that the supply is affected. Your lordship will kindly see these orders. Lordship will kindly come to page 25. The typed copy is at page 25A. Sorry, it will be 24A. Has your lordship got it, my lord?
23, 24, you are on 25A or 20?
I am on 26A.
26, huh?
Yes. 26A is the order, my lord, by which it is 20th February. Your
You
lordship
are
will-
on 93 or?
No, 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 on
Your-
227. Writ petition 227.
Yes.
It will be annexure 3, page 25.
Yes.
And the
25A.
typed copy is at 25A. Now kindly see. The governor of Arunachal Pradesh is pleased to extend the contract period in respect of the following manufacturers for manufacture and distribution of ready-to-eat food items to Anganwadi centers, etc., etc. during the year 2023-24 till finalization of the next tender process. That is the tender process which is under challenge now. Till finalization of next tender process, as per the terms and conditions as stipulated in e-tender number so-and-so dated so-and-so. Now, out of these manufacturers, my lord, my learned friend's client, Mr. Das's client is at serial number 1, Roshina Uddhag. So, by virtue of this order, my lord, he is also enjoying the benefit of interim order. Because that was the observation of the Honorable Court, verbal observation of the Honorable Court, that the interim order will prejudice none. Even the government will be benefited because of the interim order, because government will continue to get the supply at the old rate. So what prejudice, that's why the big question, what prejudice is caused to you that you are coming to file an application for vacating the stay, because the stay order is also favoring him. He is a sitting supplier, my lord. As the writ petitioner before your lordship is a sitting supplier, he is also a sitting supplier. So he cannot, logically and legally, he cannot complain. It was just a, my lord, act of grace, I should say, that I did not object on that day when he won. Kindly see the order of 20th March once again. The Honorable Court did not issue notice on him specifically on 4th of March because of the fact that he was pro forma. And the kind of relief that I am asking in the writ petition is not against him, it is against the government. So therefore, no rights of him and neither the rights of the pro forma parties were to be affected, not even the prior rights of the government, because this order was taken into account, which I have just now read out to your lordship. So therefore, my humble and respectful submission is this: the lordship will issue notice on the matter certainly, and also pass the similar order as have been there in the other cases. And if necessary, your lordship can keep it on 10th. Let them file their application of whatever application they want to file. If they file some application, naturally I will object. I will also have my right to file an objection, because impediment is not a matter of right. That your lordship knows. That's my humble submission.
Yes,
I'll
Mr.
just give a reply. My lord, just 1 minute, I'll give a reply.
Yeah, yes.
My learned friend has said 2, 3 things. First, he said, under what law? That's first, under what law you are, because we have not made a party. I want to ask my learned friend also, why he has not made as a party, knowing fully the proceeding. I'll just, please, Mr. Dotto, 93 of 2024 in respect of both the parties. Subject matter is the same. Why he is not made the party? Okay, my lord, it is a duty of us. Your lordship knows how many proceedings your lordship has dealt. If the party is same cause, same, my lord, corrigendum has been brought notice to the court by in 93, what made him not to make us a party, even as a performer? Your lordship, it is very clear. You want an ex parte order. That's all. That's just, and my learned friend said that it's an act of grace. My lord, we doesn't come to court of a grace of somebody. We argue the matter. It is up to the court to pass an order. If your lordship feels that my argument is not tenable, your lordship will not pass the order. So my humble submission before your lordship, knowing fully that we are party, same party, at least my learned friend client should have made us a party before passing an interim order. So my humble submission is that, my lord, no order, my lord, with great respect, I'm saying no order should be passed. Let this matter fixed on 10. Now heaven will not fall. That's my submission.
No, just one reply, my lord. There is a concept of dominus litis in civil as well as criminal litigation. It is my prerogative as to whom I should make party. Nobody can come and dictate me to whom I should add as a party or not. Unless he can, of course, show that some of his rights are prejudiced then only he will become a necessary party. That is a fundamental thing in all proceedings, my lord.
I know, my lord.
Since I am the writ petitioner, my lord, I am enjoying the status of dominus litis. I know against whom I should seek relief and whom I should make party. Now, if your lordship says that this writ petition is bad for necessary parties, your lordship can pass that order. If your lordship feels that this, taking note of his submission, my learned friend's submission, that he is a necessary party or he should have been made, if your lordship feels that this writ petition should go on the ground of non-general parties, your lordship may pass that order.
I have not, my lord, I'm sorry to say, I have not said anything that writ petition should be dismissed of non-general party. I said that you should have made us a party. I'm not saying that it should be dismissed.
Okay.
Yes, I'm deeply obliged.
Any
my lord.
comments or anything to say?
Your Worship, pass over this matter till Monday, Your Worship, then, along with the other writ petition, Your Worship, which is already been fixed on 10th.
No, that may be fixed on Monday.
Yes, Your Worship.
But in regards to interim, he had some submission, and other side also I have heard. In that context, do you have anything to say?
They did not even at the first stage, my lord, they did not object to the interim prayer. In the all the writ petition, your lordship, the order sheets are before your lordship can see, verify.
Otherwise, what are the matters which were fixed in 10th, in fact?
On 10th, my lord, 93 and 115, these two matters are fixed on 10th.
Fixed on 10th.
Yes.
My lord, I'm sorry.
And
to
in
say-
both these cases, my lord, the interim orders are continuing till 10th.
What the government advocate wants to say, my learned friend can't say, Mr. Doctor, that in other cases there was no objection from the government side. I'm sorry to say that. Government has to say that.
Well, the order sheet will reveal, my lord. I am not saying out
Maybe
of
order
my
sheet will
imagination.
reveal. That's a different order.
Saying on the basis of the order sheets.
Yes. I am deeply obliged, my lord.
Okay. I have a meeting, in fact, so I'll pass the order. Maybe it may be uploaded by 4 or 3:30 or 4.
Obliged, my lord.
I have an urgent meeting with you. I'll pass the order.
Yes.
Obliged. Your Worship.
Okay. Did all the files you give me, these 3 or 4? Oh. You are leaving.
Yes, ma'am.
You are going back to Guwahati today or?
Yes, going back to Guwahati. That's why I said, my lord, on 10th, I may not also be here. But
Other 2 matters are 10th. They said what we ordered will pass it is.
yes, that is different.
Otherwise, maybe fix at 10 because